Good morning, good morning, good morning. How is everybody today? My name is Debbie. Welcome to my channel. I am so glad to be back with y'all today. I hope you guys had a wonderful weekend. Welcome in, everybody. Hey, Jennifer. Hey, Judy. I hope you guys had a fantastic weekend. It's so good to see you guys this morning. We are on our part 99 of the Phil Spector trial. We are almost finished. Today, we are going to watch them get ready for closing statements or closing arguments. Sorry about that. Closing arguments. And I don't know if we're going to get to closing arguments today, but we will be done with this trial this week. I don't see any new trials coming up on the horizon. Donna Adelson's trial starts August 19th. I don't know if that's jury selection or testimony. So we've got about 2.5, 3 weeks until the next big trial starts. So we will definitely be done with Phil Spector by then. I was thinking about doing Charlie Adelson's trial before Donna Adelson's trial. Charlie's her son. Um, but I don't know if we'll have time for that or not because I know nothing about her case, which is Charlie Adelson, Donna Adelson, and Wendy Adelson conspired to unalive Dan Markel, Wendy Adelson's ex-husband. So Charlie has had his trial. He was found guilty. Now Donna Adelson, the mother of Charlie and Wendy, is going to have her trial on starting August 19th. And I know nothing. Well, I shouldn't say nothing. I know very little. But so that's going to be the next big trial that we do. I have and I don't know of any other small trials that are going to happen between now and then. If anybody does, let me know. Um So let's see what trivia Judy has for us today. Several women, including one of his wives, complained that sleeping with Phil was difficult due to the strong smell of acetone. He used fingernail polish remover to dissolve the wig glue from his head. Ew. Don't they have like some special wig glue solvent that doesn't smell nasty? I mean, even nail polish remover has fragrance. You can get the kind with fragrance. That's gross. And we have an update. Adam Lally continues his testimony tomorrow in the Walsh hearing. Proctor's due to testify. Will he show this time? Is he back from vacation? Are they streaming that, Judy? Because we could watch that if they're streaming it. But we didn't watch the first one. Did they stream the first one? I don't know. They haven't been streaming the Walsh hearings. I know I did one of them, but it was like, the way Court TV does the thing where it's like a news broadcast where they show part of the hearing and then they go back to the talking heads in the studio and then they go back and do part of the hearing. I did a Brian Walsh hearing like that. I hate it when they do that. We had to do the Ali trial like that one day because the judge got upset with the cameraman, remember? I hate it when they do that. I don't want to do a hearing or a trial like that. It was shown after the fact. I don't like I don't like to have to cut out people talking and stuff like that. I just want a hearing, just a plain hearing or a plain trial. I don't like to do it like that. But Yeah, I want to do the Brian Walsh trial. When is that one scheduled? Does it have a date yet? And I still Oh wait, I think Flash did say, cuz my question was how do we know if there's no body? How do we know she was dismembered? Cuz they're calling it the dismembered wife trial or something like that. So my question was how did they know she was dismembered if they haven't found her body? Which I think is a valid question to ask. But then Flash came in and said that I think it was Flash, that they had found her DNA on a saw. Hey, Nancy. So if that's the case, then that makes sense. Nancy, you're not green. Did you change your screen name again? Why are you not green? Okay, let's go ahead and get started. Because as much as I've enjoyed doing this trial, and I have, I'm ready to be done with it. It's a long one. It has been a long one.
Present. The defendant's not pursuant to 977. The people are present. Okay, how do you want to do this?
Well, good morning. First thing I'd like to do is I'd like to introduce Dennis Reardon to you, Your Honor. Mr.
Hi.
Reardon is part of the defense team.
Okay.
I wanted to introduce him to you.
All right.
Previously met.
Thank you.
Things that I'd like to do before we begin with the defense binder of exhibits is there are 7 emails that were read to variously. All of these emails were read to Dr. Pena, and he took these in consideration in coming to his conclusions. They weren't previously marked. I was not aware of at that point, early on in our case, I wasn't aware of what the defense was planning on doing with emails, etc. I read them again to, or at least some of them again to DeMaio, but all of these have been, the foundation has been laid as having come from Lana Clarkson's computer. Dr. Pena has read them, and I'd like to mark these 7 emails as the people's next in order, starting with 197.
Next is, let me just double check.
And I'll hand these to Mr. Porter in 2 seconds as soon as I read the mark.
197.
Thank you. I'll mark these in order, and as soon as I'm done, I'll hand them to Mr. Porter.
Excuse me, these are 7 emails?
7 emails.
And then we'll just need a moment to check them.
Sure.
Could we perhaps pass the issue until we have a chance also to look at the testimony that would be the nexus to the examination?
Sure.
I think it's probably more than a moment.
Okay. I'll go. I have some things I can do up here.
Yeah, I was thinking, as a suggestion, we have 2 sets of exhibits that have not yet been either argued or addressed or moved. The first set, of course, are the defense exhibits.
Right.
But there's also a second set, which are the exhibits that the prosecution marked and had identified throughout rebuttal and surrebuttal. So I was just going to say, I don't think there's that many of those. If you wanted to start with that small group, you want to do that first?
Yeah, either way.
Okay, why don't we start with that small group first? I think where we left off, and we do have a people's exhibit list. Mr. Ocampo, what number did you suggest that?
155.
155, okay. So we're at 156. And what we thought, Judge, I'm sorry, we're at 155, which is a database of leading causes of death. What I think has been suggested, I believe that Mr. Jackson and I chatted about it, and it might be very helpful, is instead of wielding these exhibit books, which are somewhat cumbersome, and we only have 1 copy of the defense exhibit books and 1 copy of the prosecution, we thought what might be best is if we just put it up on the screen. And that was
fine.
Is that okay?
Sure.
Okay. So we'll start with 155.
And unless otherwise noted, Your Honor, we are seeking the admission of all of these.
Okay.
Judy, they hired somebody to take Cutler's place, apparently. Do you know anything about the new guy? Rosen introduced him, but I forgot the name already.
I think we're going to need to pose an objection to this, Your Honor.
Okay. It was used in the cross-examination or examination of,
Yes,
Dr. DeMaio.
Dr. DeMaio, I believe.
okay.
Yes.
The objection,
Was relevancy, materiality, no foundation.
well, I know he was asked if he was familiar with it. It was taken from, I think, CDC, as I recall.
Right.
Yes.
Okay.
Well, purportedly, yeah. It's hearsay, though.
I understand that.
And he didn't rely upon it for his opinion. In fact, he was asked about it, doesn't make it admissible. Even if you rely upon it, doesn't make it admissible.
Do you want to be heard?
He actually indicated that he was aware of these statistics, that poisoning was the leading cause of suicide death among women, which was in opposite of his original direct examination testimony, wherein he said firearms were the leading cause of suicide death among women. And when I showed him this, he said, "Oh yeah, well that's fine, but blah blah blah."
But he did not rely upon it in forming his opinion.
Yeah, the problem is that this is between ages 35 and 44. It's just a different way they keep statistics. So this doesn't really contradict what Dr. DeMaio testified about. And that's what he, I think, said. There's really no foundation from this. They basically printed it off the internet, and you know, who knows whether this is an accurate record of CDC that's been pulled off the internet.
Anything further?
Submitted.
The objection is sustained. Although the testimony is admissible, and you can point that out in argument, there are certain questions as to the reliability of this, what the basis of it is. And there's also things that are irrelevant. You got the point which you wanted, that you had information that was inconsistent with Dr. DeMaio's testimony about the leading cause, but the document itself has too many problems with it. I'm going to sustain the objection.
Next. 156 is next, Your Honor.
All right.
This is a note to Dr. Kudrow, date stamp 6719.
Are these the ones you have objections to? Or just going to go?
No, we're just going to go through them. We just got the list last night.
Yeah, this is okay. We don't.
This is fine.
Okay.
This is actually duplicative of what the defense has actually marked as well, I believe.
Yeah, my thought is that this can come in and we'll just withdraw ours. And
If you wish.
It's fine.
All right.
it's just
fine.
one-page document, as I
It's received.
Okay. Then we have 157 through 165, which is a series of photos of Ms. Clarkson's, I recall. I think there was testimony by, I believe it was the mother, Donna Clarkson, regarding a series of headshots that were taken fairly close to the date of February 3rd. Correct.
Okay, just put them one by one on there.
I'm familiar with pictures. I don't need this.
Okay.
Okay. Any objection?
Submitted.
They're received. It's your good pictures versus, or their good pictures versus your bad pictures, and the jury can have all of them to look at.
166 and 167.
Okay.
No objection.
Okay.
167 is the same thing, just a little bit different graphic.
Okay.
It's fine.
Those are received.
168 is...
We're not offering 168.
Can we see it up?
Sure.
We might want to offer it.
Okay.
There was, that's fine. It was never testified to. I marked it and it was not discussed.
See it.
It's
I don't
right
think
next
we
to
ever got a copy of it. Is it possible to clear up?
It's next to you. It's the journal entry
Right.
for the firefighter. Well, if you guys want it in, I'd love to have it in, but there's no foundation for it.
All right. It's withdrawn.
I think it was just one.
It's withdrawn. It's just marked for identification.
169.
Okay.
This is faster if we do it this way.
You noticed that, did you?
We're also not
Nothing gets by
offering,
Mr. Rubin.
sorry, we're also not offering this, I don't believe this I had it, and I think I marked it, but I marked it at the same time I marked the other one, and nobody testified to it. It's the guidelines.
Yeah, we're not offering it either.
All right, well, then it's not offered in evidence. Won't be received.
170 is next.
70 and 71, Judge, are the tape, the base hospital form tape, and the transcript.
Okay.
We're not offering, anytime we get to a transcript, our position, my position and Mr. Ocampo's position is that the transcript is not evidence, but it was marked and can be used as a guide or an aid. for the
We have
jurors.
a local rule that says if you bring in a tape, you have to have a transcript for the jury to use. If anybody wants to argue the transcript, they may. Again, I think the jury, if you want to drop an instruction, that any transcript is basically the transcriber's version of what took place in the absence of a stipulation, that it's the tape and the juror's own hearing that controls. Basically, it's a guide.
Let me ask this, is it the court's practice to send the transcripts in with all the other evidence, or do you keep the transcript out and wait for a request for it?
Transcript goes in.
We would object to that.
Yeah.
Objection is noted and overruled, and I would suggest, somebody drop an instruction just a little special that indicates that basically that's what a transcript is. It's the transcriber's version. It may be accurate, it may have inaccuracies. It's up to the jurors if they wish, if they think it's important to listen to the tape.
Okay. So
This requires obvious redaction. Go ahead and pull that off because it does require certain redactions. This was a DMV photo that was used for identification of Tawny Tyndall. She didn't testify in the case. However, she was identified as being the person who basically lied about her identity to Bruce Liverpool.
Well, she misidentified herself. Let's put it that way.
Misidentified herself. There we go.
That's called politically correct.
we're going to object to the DMV printout. Ms. Tyndall's been identified a number of times in person, live here in court, and I had asked her to stand several times to have her identified during the defense case.
That may be, but it doesn't make the photograph. It was testified to, it was identified. It doesn't make it inadmissible, so the objection is overruled. But it will be redacted to take out any personal information about
So we'll
Ms.
just
Tyndall.
have the photo.
We'll have a photograph and the name.
And everything else will be taken out.
Well, wait a minute, I think we ought to make it clear that it is a DMV photograph as opposed to some form of mugshot or something.
Why don't you put on it DMV
It
photograph?
says California Department of Motor
It's
Vehicles
on there.
image, and I'll
It's
leave
on
that
there.
on there if you want.
Okay, that's fine.
And that we would ask them.
I'll redact everything in black and leave the red writing on there.
Okay.
Just look at one quick second.
No one's accused Ms. Tyndall
Yeah, no, I looked at it.
convicted of a crime.
I'm fine with that because the writing does say California Department of Motor Vehicles, image Tawny, delete Tyndall, and then the rest will all be redacted. That's fine.
Okay.
Even though we're going to oppose our objection.
Yes.
Okay. 173, I think is next.
173 is a
I think the court's ruled on this already once.
I think so.
resume. I don't remember.
I'm not sure that I did rule. You may be correct. Did the agent testify to this?
You know what?
Wait.
Because
My
otherwise,
understanding was, the objection was that this not be published to the jurors. I didn't publish it to the jurors. I showed it to Mr. Terzian.
right.
Mr. Terzian indicated that this was in fact corroborative of his phraseology that she was a quote-unquote working actress. So we would ask that be admitted for that purpose.
Doesn't get dates or times or...
It still shows that she had a career. It doesn't have to be. I mean, it goes to the weight.
No, I'm sorry, but this is entirely hearsay. There's no foundation for any of this.
Well, it depends what Mr. Terzian said about it. You have to locate the testimony and see what his identification, other than he was familiar with it or it was representative, it'd have to be that he gave a specific answer that would allow it to come in.
Yeah, that's the problem with it, because much of it up there has nothing to do with him, and he isn't even aware of it.
Well, we can raise this again.
Representative.
I'll allow the people to look through the transcripts of his testimony. If they think there's a sufficient foundation, they can let me know. Put that one on hold.
And 174 is next.
We have just a second, Judge.
Sure.
We're trying to get our piles together.
Sure.
175 and, sorry, 174 and 174.
174, yeah.
Both of these are these photographs, right here. Photographs of Lana Clarkson at
Those were, I think, the commercial, right?
the last thing she
The
did.
Chesterfield commercial.
Correct.
Okay.
Those will be received.
176 is next. That's fine, no objection.
All right?
Don't you like them when they're easy like that?
No comment.
177. I think Mr. Jackson went into this with
Mr. Terzian?
Terzian, as I recall. I think.
This is the Carlos email.
Right.
And response.
Oh, right, I remember the testimony concerning that.
I think it's an actor seeking advice from her.
Yes.
Right?
Correct.
Yes. Certainly.
Is that, and it's sent by Ms. Clarkson, right?
Correct.
I think at the
Yes.
end, okay.
The bottom part is her response to him.
Right.
It's fine.
It'll be received, thank you.
Can I have just a moment, Judge?
Yes.
Did- 178 through 180, 3 photographs. Might be a little quicker. I can just show Roger what these are. It's 3 photographs of Lana Clarkson.
This was with Neely Hudson. And what are the numbers on that?
178, 179,
And 180.
180.
Yeah, I don't have a problem with that.
Okay, those are received, thank you.
The next one is the pumpkin pie letter, both sides of it. And that's 181.
I'd like to find an objection for it, but I just can't think of one.
Well, on your wish list then, but they'll be received.
Your Honor, the
Is it too early to file that with the court? Your Honor, they are not seeking to introduce 182, which is the Christmas card, I believe.
that's correct.
But we're going to offer it. And the reason is this.
I'll admit, it's part of the package, it's been testified
Yes.
to, I'll allow it in.
Thank you.
All right.
Okay. Right, right. 183 is a photograph of Ms. Clarkson and Mr. Bay, foundation for which was laid.
Yeah.
Mr. Bay's testimony.
All right, that'll be received.
184 is the actual Pyrenees Castle sign at the time of the,
Wasn't that done by stipulation? I could be
I
wrong.
think it was.
It may have been. That's what we used as a sign when the jurors did it.
It'll be received.
Okay. This was done by stipulation as well. 185 is a lease, a rental agreement lease.
Is that base stamp, by the way?
The rental agreement?
Right.
This is the Clarkson rental agreement for the cottage, right?
That sounds familiar.
AJ, isn't this the... Yeah, we stipulated to this, Judge.
Yeah, we did.
Okay,
We just need to get a copy.
it's received, thank you.
Judge, the following I don't have. Wendy actually has them, and you can take a look at them from her. It's the Ross Dress for Less receipts.
City stuff.
That's for the shoes that Mrs. Clarkson testified to?
Correct.
Okay, that'll be received.
187, 188, 189 are all mannequin pictures, the foundation for which was laid through defense experts.
No, I don't think it was. These pictures were taken by the Sheriff's Department after Taylor apparently took samples. The defense experts weren't there when the samples were taken. They were just asked questions whether samples were taken.
Wait, when he says Christmas card, is he talking about that Christmas letter that Pumpkin Pie wrote? Because why wouldn't the prosecution want that in? Because she said that's the one where she wrote that Lana died at the hands of Phil Spector. The prosecution should want that in. Not... I'm confused. Maybe they're talking about a different Christmas card? I don't know. Okay, Judy comes through for us again. New attorney, Dennis Riordan. Mr. Riordan is here to work on jury instructions, Fiddler said. He said Riordan would be considered a member of the defense team while assisting with jury instructions. Alrighty then, jury instruction lawyer. Okay, that's weird.
Separate. So I don't think there's been a foundation as to these.
For these photographs, there was...
What hasn't been weird about this trial, right?
Testimony,
Let's take them one at a time.
right.
This one was taken by the sheriff's department after the samples were taken, and I asked the defense experts if that location and that location was where Mark Scott Taylor took the samples from the lapel and the shoulder area, and the testimony was yes, it was.
They said they weren't there when it was done. Now, I think inferentially that's probably correct, but what happened is that Mr. Taylor was directed to do that like in May, and then he didn't do it till the following January, and so this is the results. The experts weren't there when Mr. Taylor actually took the samples.
That may be, but if they testify that that's correct because of information that they have or whatever, if they didn't indicate they were just guessing, then it's going to be admissible.
And that was Dr. Bodden.
All right,
Excuse me, is this one 187?
That was.
Okay.
okay.
And this is 188?
Yes.
That's fine, I'll submit that.
All right,
We'll
there-
just note our objection and move on.
Okay, they're received.
Thank you. The following is
190?
190 is an email from Lana Clarkson. It's to Eric Patricia.
Yes, this was, I think Mr. Patricia testified about this, and I think actually the questions asked on direct and cross about it, as I recall.
It'll be received.
191 is the response from Mr. Patricia to Lana Clarkson from that email.
It'll be received. Thank you.
Thank you. 192 is additional, 192, 193 are additional photographs of the defense team utilizing mannequins. That was testified to by Dr. Bodden, as was
It'll be received.
that
Thank you.
photograph.
It'll be received.
Thank you.
194 is the letter that Deborah Robitaille testified to.
That's correct.
A letter of employment, as I recall.
Okay, that'll be received.
Thank you. The following 195, I don't have the printout. I think Wendy's got the only copy of it. It was the one that the court indicated when Mr. Stark was on that one. When Mr. Stark was on cross-examination, I couldn't publish it. I couldn't ask him certain questions about it.
He
We're not offering it.
wasn't familiar with it. Yes, if you're not offering it,
No.
that takes care of it. Okay.
I didn't know if the defense had an argument
No,
on it.
that's fine.
Okay, not received.
And this is an artful rendition of a spinal cord.
We want to object to this one, Your Honor.
Yeah, it misrepresents what's already in the record, and that, this is,
That's the page itself. The actual page itself.
Actually,
It
that's-
does not have the arrows.
Well, let me clear something up. The page itself is absolutely not what was represented. It was Mr. Spitz, Dr. Spitz, who hand drew something. I just did a little better job and did add some arrows. I did add the arrows, but Dr. Spitz testifies went up the vagus nerve, and the outgoing neural impulses from the medulla oblongata in those areas did go down southbound down the.
That may be oversimplification of what Dr. Spitz testified to. I think at some point Mr. Jackson got him to acknowledge he wasn't sure.
Because anything you say about Werner Spitz's testimony is an oversimplification, because that man makes everything that comes out of his mouth convoluted, because the man cannot make anything simple. So by definition, anything that you paraphrase that came out of the man's mouth is an oversimplification.
About those things. He wasn't familiar. He hadn't even heard of the vagus nerve to his recollection. And I don't think that he affirmatively testified that that was the direction that the nerve impulses went. I think what happened is Mr. Jackson got him to assume that for the sake of the questions and then ask him about the severance of the spinal cord and so forth. So I don't think that Dr. Spitz claimed to have sufficient knowledge to.
Did he just say that Spitz had never heard of the vagus nerve? I don't think so. I think you need to go back and listen to his testimony, dude. No doctor has never not heard of the vagus nerve.
Lay a foundation for those arrows.
The drawings were all used during the cross-examination of the witness. You can go back to the testimony, and if you want to argue at a certain point, if the drawings are used, that's not, this is what the witness said in response to this drawing, but they were used. They weren't purported that they're anatomically 100% accurate. They were used to illustrate various parts of the testimony of the witness. It'll be admitted.
And that's all for us, with the exception of the emails that I just gave to Mr. Plord.
What about the phone records?
We completely forgot about those.
Wait, who's got the email? Are those only ID only, or are they admitted?
No, I'm seeking the admission of those emails as well. Those 7 emails that I just marked, I'm seeking the admission of those as well. And the phone records, I guess I'd need to mark the phone records.
We will need to mark them, and then we
Judge,
can...
did we give you a packet of...
You did?
Are they all together? Do you want me to mark them as one item?
Just,
altogether?
well, please, we don't need all separate numbers, just one package of phone records. So
They are separated between
it's okay.
Hayes and Clarkson. Still one.
Still,
That's an envelope contained.
Perfect, that's fine.
okay,
So that'll be 204, the phone records.
Okay.
And we're seeking the admission of those as well.
okay.
I'm sorry.
Hold it. Everyone stop. Before we get to the phone records, we need to deal with emails. I just wanted to remind you that the phone records were on the table.
Thank you.
Okay.
We're talking about 197, correct?
we are.
197 through 203.
Mr. Ford is looking at those.
All right.
I think the emails that we're talking about are ones that were paraphrased to witnesses and so forth. Now, whether this is the one that we have a real objection to, we're not sure how that was, I don't remember how that came in.
This was on the second page. On the second page, there was an Evite, and on the second page of which is Lana Clarkson responding to the Evite, saying, "I can't wait, hugs and kisses, Lana." She responded on February 2nd,
Right.
2003.
We'll submit.
Okay. That'll be received.
Which number was that?
That is number 201.
Do you have any specific objections?
Yeah, as to the rest of them, we'll just submit, Your Honor.
That'll be received.
Thank you, Judge.
Now, let's talk about the phone records.
So that was 197?
It's a group of 7 emails, 197 through 203. 203. They are received.
Okay, now.
Now we're on 204, which is an envelope and its contents containing phone records of Ms. Hayes and Ms. Clarkson. I've never looked at them, so what are you using them for, and what's the basis for them?
The basis for them is to establish the phone records back and forth, the phone calls back and forth between the parties.
To show?
Cell phone records. To show the level of their contact.
Is there some foundation that these records are relevant to the phones that were being used for the purported contact? I think what the thrust of the evidence is, if I understand it, is that there was testimony that there was frequent contact, and these particular phone records do not show frequent contact.
That's the argument.
Yeah, and actually that actually was covered, though, in a different way. Miss Laughlin made it very clear that she... let me back up to you. The reason they were originally offered was it was the prosecution's contention that Miss Hayes was being untruthful because the phone records did not support all the contacts she said she had with Lana Clarkson. But that was all addressed on redirect, and also this last time I think she testified when she indicated that the arrangements were always made through Pumpkin Pie. There wasn't going to be any phone records because it would be Pumpkin Pie who would set it up between Miss Clarkson and Miss Hayes. So the purpose for which the prosecution originally presented these potential exhibits to the court were on that theory. That theory is no longer a viable theory because Ms. Hayes has explained the fact.
It's viable. It's a question of other facts that the jury may choose to believe or disbelieve that this is important and shows the level of contact, but it still is relevant. I don't have any problem with that. The fact that Ms. Hayes or Ms. Laughlin explained it, the jury is free to accept or not accept that based upon how credible they find her. That's just an explanation. It's one possible explanation. It doesn't mean that it has to be taken and accepted by the jury. Her credibility is always in question. So now the question becomes, is there an adequate foundation for the records?
See the exhibit.
Okay.
The foundation is
It's 791 and 1560, I believe.
1532 or something.
1532,
Right,
okay.
I believe.
I assume that there's some sort of custodian's affidavit with them?
That's correct.
Yes.
There it is.
All right, I'm going to...
Just look at it for one
Yeah, go
quick
ahead.
second. Where are
Certainly.
they?
I think Wendy has it.
Go ahead.
You know what, just a second, they're right here.
They were
Here they are.
Can I come up and grab them?
Sure. 791 and 1562.
62, sorry about that.
It's okay. There.
Close with the cigar.
Some of these are post Lana Clarkson's death. I don't think those are relevant for either one.
I would agree. What's the relevancy, if anything?
There is not, what we did is we compiled the last 3 months, what we could get for Lana Clarkson's phone records and then Jennifer Hayes' phone
You
records.
need to redact anything after her death.
That's fine.
And also the
That's
first
easy.
two pages of the motion.
Right.
That should-
Right.
Yeah, we should put this into some type of an exhibit, and then,
Fine.
yeah, so in the first couple ones, the copy's so bad, you can probably read, I don't know if we can get a better copy, but then, it basically is two cell phones, Lana Clarkson's cell phone and Jennifer Hayes' cell phone.
I'm going to admit them, subject to redaction, subject to taking the front page of the motion off so that they can be put into an exhibit form, 2 pages, and then they'll be received, and you can argue your little hearts out as to their importance.
And everything.
Personal information redacted as
Yes, if there's any personal information,
Of course.
it needs to be taken out. Okay. That is next in order for people. 204 envelope and contents.
204.
Okay.
And that's all we have, Judge.
Okay, well, that takes care of your exhibits. Let's move on to the defense.
Judge, we have prepared a defense exhibit list, and
Yes.
we've actually, you got it?
Yes, I do.
Okay, this should make this a little easier. With regard to, just so you know what, I saw that.
I don't, this should make it easier. It's like a guarantee it won't, but I appreciate the effort.
That is so not fair. All
I
right,
know.
where, just so you know, the object is pretty self-explanatory.
Okay,
Where it indicates keep, for
Yes.
instance, second from the bottom.
Exhibit V, okay.
Correct. That is one that the defense is seeking withdrawal of, but the
Okay.
people are requesting admission of.
I understand.
Okay? If
Okay,
it says agree, which you'll see a couple of times, the defense is requesting withdrawal, and we have no objection to that. We'll withdraw it.
okay.
Okay?
you.
Otherwise, here we go.
Can we
Yes,
put a comma on it for just 1 second?
sure.
Jen, where are you? Do you need a little more time?
Let's start. Let's go.
Okay. I'm going to mark it where you've stopped, okay? Okay. All right. I guess the best place to start is at the beginning, as they would say.
We may, just to, again, my efforts to make things easier, we've also mentioned what the item is, so we may
Yes.
not have to force Jen to put every single item on the board. For instance, the first 1, 2, 3, 4, 5, 6, 7 items bear the same objection.
Okay.
They're all items that were shown to either Dorothy Melvin or one of the 1101B witnesses. I think all of them, Dorothy Melvin. Our objection is that it doesn't show any state of mind of the defendant. All it does is corroborate that the defendant, after the contact that he had with her, the violent contact, I'll call it, the 1101B contact, the incident, he continued to write her. There's no indication that she maintained a connection to him. So this doesn't show any state of mind that's relevant on
I think she kept them, did she not?
She did keep them, but she
Okay.
didn't write back. So they, on their face, just show, there's guys in prison that write their victims.
And people often throw things away that they don't like or don't want to keep, or it's a bad memory. Although it may not be overwhelming, it's still, to my mind, they're admissible.
Okay. So
So that would be, let's see,
A through G.
A through G are received.
Just for the record, I think Dorothy Melvin did indicate that she had sent him some jokes on emails a little later.
Would you like, as I often say, you won? Would you like to get me to somehow? Thank
Is
you.
this the right response?
An excellent response.
Okay.
Thank you. Let's see, H, tape recording of message left for Diane Ogden Halder.
No problem.
Okay, so that's received.
The transcript, the same issue with the transcript. It's marked, it's not the actual evidence, but I think the jury instruction will take care of
Right,
that.
I will be received as well. J is the Inquirer contract.
Right. And we object to that because it's not inconsistent, it's hearsay. It's not inconsistent to anything. As a matter of fact, Stephanie Jennings admitted to everything in the contract.
Okay, but the bottom line, it's just a corroboration. It's a piece of evidence that shows that the contract existed. She basically testified to it and agreed that that is the contract.
I absolutely agree. My position is it's hearsay. It doesn't, there's no exception to the hearsay rule. If she was inconsistent and said, no, I never did that, and then this was brought in, it would be an inconsistent statement.
Well, it would be hearsay without some, and it's a statement of truth, but she has stated, this is my contract. It's corroboration of her testimony, and that can be a grounds for admissibility. I'm going to receive it at this time. So J would be received. The next, K, L, M, and N are all documents dealing with the plea agreement and the notice of proceedings and information and judgment in U.S. District Court against Ms. Grosvenor.
Our position is the only thing that's admissible on those documents, we don't have necessarily a problem with the first two documents. The court, the charge, and the date should be admissible. Everything else is hearsay. There's no exception to the hearsay rule, and there's no reason for anything other than the court, the charge, and the date to be admitted. With regard to the plea agreement, which is M as in Mary, the plea agreement is clearly hearsay and not relevant to anything. I mean, she has, for credibility purposes under Wheeler, she was impeached with having a conviction. None of the plea agreement or the specifics of the plea agreement should have been admitted or should be admitted.
Okay, I'll hear from the defense.
We think it's all part and parcel of the proceedings, number one. Number two, it's not hearsay because she signed it. And she signed it with the advice of counsel. And she knew she was signed because she went over it with counsel before she signed it.
That may be, but the question is what is admissible for the purpose of showing a felony conviction, which is what it's being received for.
You know,
The underlying facts are not admissible.
I'm going to let the court make whatever call it's on the plea agreement.
Oh, thanks.
Okay.
I plan to do that anyway, but I like the agreement. As indicated by the people, they are admitted as to K and L, but with redactions of anything other than the court, the charge. And this would also, the plea agreement is out. M is out. K and L are admitted with the redactions set forth by the people. And the judgment, how much does the judgment show? Let's talk about number N.
Actually, if I can go back to your honor to K.
Sure.
K is actually a document showing a notice of arraignment, and I don't think that actually applies. I think we should go to N.
All right,
And
I
if-
would agree K is out. So let's talk about N.
L is just a description of what she is charged with. A further description.
Right. He indicated that L would be admitted just with redactions, in other words, just the count.
Okay, then go to N.
Let's go forward to N.
This actually is the federal judgment form, Your Honor.
Why is this any different than when the people put in a 981 pack or a 969? What, my numbers are off here. The prior packet.
969.
I think this is probably the most accurate document to put. It shows the section, the charge, as well as the date.
Right. If N comes in, then nothing else needs to come in.
Well, I've indicated that L is out.
No, L is in.
L is in. K is out because it's just a notice of proceedings. L is the charges. The judgment, which is N, will be in as well. So K and M are out. L and N are in. Okay. The next would be O, which is the Continental Airline employment application.
Right.
And we object to that because it's rife with hearsay. I mean, she was impeached on it. There's no exception to the hearsay rule to get this information in. She specifically said, and it wasn't an inconsistent statement, when she was asked by Mr. Rosen, did you fill out a form? She said yes. And did
Well, but you can get in the document that's the actual perjurious statement, if you will. So that's the bottom line, is she signed it under, I believe, under the pain and penalty of perjury, and she indicated that she had, I believe, had either not been convicted. Whatever the allegation was, the document's going to come in.
Okay.
So O is received. There's a,
Aaron, may I just have one
Yes.
moment with Jen?
certainly.
Housekeeping matter.
Okay, no problem.
We're on P now.
No objection.
There's no objection to P, Q, R, S, T, and U.
So let's just go to V.
Yeah, so all of those, well, we have to receive them, they're all received. Next is,
U and V, Judge, you have to kind of look at those together. What the
Okay.
defense has done is they've asked for the admission of D'Souza and his tape, the microphone, the kind of 8mm tape when he was doing the walkthrough at the fountain.
right,
They've asked for portions of it, but not all of it. So they want the portion where it indicates the fountain. And you know, well, I'll leave my comments on that for another time. The jurors have actually heard the actual fountain, so they can make a determination if it's accurate. However, D'Souza goes on during that same course of conversation and talks about where Spector was with the gun, where he saw him, et cetera, et cetera. That's V. If U comes in, V under 356 should come in as well. They shouldn't be able to pick and choose the end.
First of all, we have the whole hour tape that has already been admitted, so, but 356 isn't the appropriate analysis unless there's some foundation that they're talking about the same subject and they talk about different subjects, and we used that portion of the tape for a very narrow purpose. The balance of it was not admitted at that time, so it shouldn't be admitted now. It's just the part that the court admitted at the time the exhibit was offered.
I guess the question is, something I've never bothered to think about. When one party marks an exhibit, of course, everything belongs to the court, if you will, but you've marked an exhibit. Now you seek not to introduce it, but the other side wants to. The question is, can they do that? My answer, I'm pretty sure that either side can do that. And then the other question, the next question is, does it go to something that's admissible?
The first part, I don't disagree with the court.
Right.
That is correct.
Right.
That's absolutely correct.
But the latter part, I mean, 356 does.
It doesn't have to be under 356. The question is, does that tape show something that has been testified to and otherwise is useful to the jury? Is there any basis to keep it out? Other than you don't particularly, it's not something you would like to have in, or it didn't illustrate a point that you liked. It's been testified to, clearly.
Portion of it, yes. Not the entire tape. That's why the three. And even at this point, it would be too late to expand it under 356 analysis. The portion of the exhibit that was offered and testified to is what is being offered at this point. There's no foundation for the balance of it. It wasn't played. He wasn't cross-examined about it. There's no evidence about it.
All right, Mr. Jackson, your
I think
response.
that's factually inaccurate.
Okay.
I'm curious about, and maybe Wendy can help us, with regard to U and V, the defense has indicated the tape portion of U at 5 hours, 12 minutes, and 14 seconds through
5, 12,
48.
right. So they're offering 34 seconds of it.
Right, and my position is whatever was shown to the jury and whatever was used on cross-examination, that's what should be admitted. I mean, you can't pick and choose and edit 10 seconds
I agree.
out
I
of
think that what they're saying is that, and this is, I'm not there yet because I don't know the facts. They're saying that V, that portion of the video was not shown, which is 5:19:40 to 5:19:49. That those 9 seconds were never shown, is what they're alleging. So therefore, they're not admissible because there's no basis for admissibility.
Well, if that section wasn't shown, then why is it marked as defense V?
I don't know.
That doesn't make any sense to me.
We need to go,
Exhibits get
it's real
marked.
simple. You want to, there's an easy way to do this. It was, well, when I say, all you have to do is find the date it was introduced, which is, let's see, it was during it was on 5/21, May 21st. It was during, let's see. And unfortunately, I need is the date. Then we go to May 21st, and in the front of the transcript, it'll show you at what point it was marked. And we'll go from there.
I thought that CD wrong.
Okay, May 21st is volume 19. It was marked page 3282. Let's see.
I think we placed both of these excerpts as marked
Okay,
on the disc.
let's just see.
Here they are. Knock yourself out, Randy. Here we go.
To mark U, and you wanted to mark V. And, okay, and then the U, a videotape was played, and then the videotape was stopped. So I'm just trying to get to V. All right, Defense Exhibit V, a videotape was played. The playing of the videotape was stopped. Mr. Brunon, that apparently goes from 5/19/40 to 5/19/49, Your Honor. And then I asked if it was a separate clip that could be marked, and Mr. Brunon said yes. Okay, so it appears that the entire exhibit was only a portion. V is a portion that was played from 5/19, so it was played.
And what we're asking for is, if it was played in front of the jury, we're asking for its admission.
And I don't think we're disagreeing, or you're talking about where you're at,
I just want to play the clip.
9-second portion.
It's the same excerpt.
Yeah, we're in agreement on that. I
Okay.
think we're in agreement on that.
All right, good. The exhibit is received because it's a very specific portion of the tape in the clip.
But it does raise the technical problem.
How, the jury, we will have to,
You know, I've never seen them do this before. They go over jury instructions, like that's a charging conference that they do before closing arguments. But I've never seen them go through the evidence like this before. And I'm going to do another law school 101 thing. I haven't done one in a while. Because marking the evidence, let me see. I got to get this straight in my head before I do my short. Marking the evidence for identification means that you just mark it so that it's organized, so you can refer back to it. It doesn't mean that the jury gets to see it. When you mark it for evidence, that means the jury gets to see it and you can present it in the trial. So if it's presented in the trial without objection and the jury sees it during the trial, that means it goes back as part of the evidence for the jury to see during deliberations. So I don't understand why they have to do this now. Because if it wasn't objected to during the trial and the jury saw it or heard about it during the trial, then it automatically goes back with them. So this whole thing is not making sense to me. Like, how can they object to things that the jury's already seen? I'm not following this very well. Like, I'm following it, but I don't understand the point of it. Things that the jury's already seen may not go back with them? Or am I not understanding what they're doing right now? Or, like, I don't get it. Is it me? What's happening?
I have a suggestion.
yes.
I've been through this a couple of times. It can be done one of two ways. Either you can send it in, and since it's in a case, you can place on the top of the case that if they want to listen to it, they are only permitted to listen to those portions, and then the court can have a control factor over that if it wants. Or the second way to do it, excuse me, is to keep DVD itself out and just send the case in with the note contained in the case. I've seen it done both ways, and it seems to work just fine.
Yeah, I believe that the two CD-ROMs are just the clips, they're not the full tape, and so.
Oh, that's not a problem itself, then.
We'll verify that.
Okay, just verify that so that the jury can't see something that they're not supposed to
Otherwise, you
see.
can take one of those two.
Okay, so V is received. W, people have an objection to W, which is a document, deferred action summary. Summary is spelled wrong, immigration.
Deferred action summary. Release.
Oh, right, we have an objection on foundation grounds.
Okay,
Nobody was brought in to establish the foundation for what this document is or the accuracy of the document.
this is something I think Mr. DeSouza was questioned about it, but I don't think the document itself, I'm not sure that he had any familiarity with.
That's not correct.
Folks, wait. Please try to remember something. If you talk among yourselves, if the reporter can hear it, she'll report it. And when you're all doing it at one time, it's very difficult. Thank you. All right.
This, I believe, should be can we take a moment here? That's not the exhibit.
You're saying that W is not the exhibit that should have been marked or was marked? I can tell you what W was. I mean, it's just a matter, again, we go back to the date it was marked. If you,
It's going to be 521,
okay, 521.
volume 19.
Index, it'll tell you what page it was marked on. It'll be a description. W was just let's not guess. We're going to.
She's got it right there.
Okay.
That's the correct example.
Okay. So W is actually what, Wendy?
Deferred action case summary.
Sorry. All right. That's what it is.
No, we don't have it.
Your Honor.
Yes.
Can I read over your shoulder? Sure. Obviously, he was cross-examined about it. It is one of the efforts made by the prosecution to keep him in the country pending the pendency of the trial. And it does go to his motive and bias. He was cross-examined about it. It's not hearsay. It's something that actually, even though it is true and it is an official document, it is not being offered to prove the truth of its contents. It's being offered to prove his belief that the government, that this government, level of government, the prosecution, is assisting with the federal government in keeping him in the United States.
Did he indicate an awareness of it, that he was aware of that document?
I can't honestly recall, but he certainly agreed that he was aware that there were efforts being made by the prosecution to keep him in the United States.
Well, what you need to show me, and I'm not saying that you can't show me that, is that he was aware of that document. It's something that he knew that the government was doing on his behalf. If he's unaware of it, and it doesn't go to his bias or anything else, he has to be aware of the government. And yes, I was aware that they were trying to help me out.
He did say that. I can tell you that he was aware of that.
And I understand that, and the question is, was he aware of this document?
Those are two different questions.
Okay.
This document incorporates the effort that he was aware of. It corroborates the effort.
Let's find the testimony concerning the document. It'll make it a whole lot easier for me.
It would be towards the end of the Bruno's cross.
Right where you looked at W
Okay.
is where he's going to have marked it. And Judge, while you're at it, you might as well look at X and Y as well.
Okay.
W, X, and Y are the document that we're talking about now, and then two letters by Mr. Sortino to, I guess, INS or ICE or somebody, and to United States Immigration. And specifically, my recollection is, and you'll find it in a second, Mr. D'Souza said, all this stuff went through my attorney. I didn't see any of it. I don't know anything about it.
Okay. Let me find the documents, and then we will go from there. Well, Mr. D'Souza testified that he was familiar with the contents of the document. He did that on page 3290 of the transcript. He remembers getting the document. He doesn't remember when he got it. His lawyer gave it to him at the immigration building. I'm paraphrasing. I'm sort of going through the testimony. So he's familiar with it. That goes to possible bias, so clearly W is going to be admissible. X is a two-page letter.
For Mr. Sortino.
All right.
As was Y.
Give us a second.
What just happened? What just happened? Uh-oh. I have no idea what just happened. What just happened? Court TV's website just crashed or something right in the middle of the thing. What is it doing? Good gravy Marie. That was not StreamYard this time, y'all. That was Court TV's website. It was like, nope, I'm done. And I don't even know where we were.
Was offered and testified to is what is being offered at this point. There's no foundation for the balance of it. It wasn't played cross-examined about it. There's no evidence about it.
All right, Mr. Jackson, your response.
I think that's factually inaccurate.
Okay.
I'm curious about, and maybe Wendy can help us, with regard to U and V, the defense has indicated the tape portion of U at 5 hours, 12 minutes, 14 seconds through
12:48.
Beauty.
They're offering 34 seconds.
Right, and my position is whatever was shown to the jury or whatever was used on cross-examination, that's what should be admitted. I mean, you can't pick and choose and edit 10 seconds.
What they're saying is that, and this is, I'm not there because I don't know the facts, they're saying that B, that portion of the video was not shown, which is 5:19:40 to 5:09:49. Those 9 seconds were never shown, is what they alleged.
Well, now StreamYard's misbehaving. I spoke too soon.
We need to go, it's real simple. You want to, there's an easy way to do this. It was, all you have to do is find the date it was introduced, which is, let's see, it was during it was on 5/21, May 21st. It was during, let's see, my notes, unfortunately, it all I need is the date. And then we go to May 21st, and in the front of the transcript, it'll show you at what point it was marked. And go from there. Okay, May 21st is volume 19. It was... It was marked page 3282. Let's see.
I think we placed both of these excerpts as marked.
Okay, let's just see.
Here they are. Knock yourself out, Randy. Here we go.
Mr. Brunon has indicated he wanted to mark U, and he wanted to mark V.
Yeah, if it's a Baby Yoda invasion, if it's a bunch of Grogus, I'm fine with that.
And, okay. And then the U, a videotape was played, and then the videotape was stopped. So I'm just trying to get to V. All right, Defense Exhibit V, a videotape was played. The playing of the videotape was stopped. Mr. Brunon, that apparently goes from 5/19/40 to 5/19/49, Your Honor. And then I asked if it was a separate clip that could be marked, and Mr. Brunon said yes. Okay, so it appears that the entire exhibit was only a portion. V is a portion that was played from 5/19, so it was played.
And what we're asking for is, if it was played in front of the jury, we're asking for its admission.
And I don't think we're disagreeing, or you're talking about what you're, the
just want to play a clip.
9-second portion?
It's the same excerpt.
Yeah, we're in agreement on that. I
Okay.
think we're in agreement on that.
All right, good. The exhibit is received because it's a very specific portion of the tape in the clip. Okay.
But it does wrinkle problem.
How, the jury, we will have to,
I have a suggestion.
yes.
I've been through this a couple of times. It can be done one of two ways. Either you can send it in, and since it's in a case, you can place on the top of the case that if they want to listen to it, they are only permitted to listen to those portions, and then the court can have a control factor over that if it wants. Or the second way to do it, excuse me, is to keep the DVD itself out and just send the case in with the note contained in the case. I've seen it done both ways, and it seems to work just fine.
Yeah, I believe that the two CD-ROMs are just the clips, they're not the full tape. So,
That's not a problem itself, then.
We'll verify that.
Okay, just verify that so that the jury can't see something that they're not supposed to
Otherwise, you
see.
can take one of those to suggest.
Okay, so V is received. W, people have an objection to W, which is a document, deferred action summary. Summary is spelled wrong, immigration.
Deferred action summary. Please.
Oh, right, we have an objection on foundation grounds.
Okay,
Nobody was brought in to establish the foundation for what this document is or the accuracy of the document.
Mr. DeSouza was questioned about it, but I don't think the document itself, I'm not sure that he had any familiarity with.
That's not correct.
Folks, wait. Please try to remember something. If you talk among yourselves, if the reporter can hear it, she'll report it. And when you're all doing it at one time, it's very difficult. Thank you. All right.
This, I believe, should be, can we take a moment here? That's not the exhibit.
You're saying that W is not the exhibit that should have been marked or was marked? I can tell you what W was. I mean, it's just a matter, again, we go back to the date it was marked. If you,
It's going to be 521,
okay, 5/21.
volume 19.
Okay, and if you look in the index, it'll tell you what page it was marked on, and you can see. It'll be a description. W was, let's not guess. We're going to,
She's got it right there.
Okay.
It's on there.
That's the correct example.
okay. So W is actually what, Wendy?
Deferred action case summary.
Sorry. All right, that's what it is.
We don't have it.
Your Honor,
Yes.
can I read over your shoulder? Sure. Obviously, he was cross-examined about it. It is one of the efforts made by the prosecution to keep him in the country pending the pendency of the trial. And it does go to his motive and bias. He was cross-examined about it. It's not hearsay. It's something, actually, even though it is true and it is an official document, it is not being offered to prove the truth of its contents. It's being offered to prove his belief that the government, that this government, level of government, the prosecution, is assisting with the federal government in keeping him in the United States. So
Did he indicate an awareness of it, that he was aware of that document?
I can't honestly recall, but he certainly agreed that he was aware that there were efforts being made by the prosecution to keep him in the United States.
Well, what you need to show me, and I'm not saying that you can't show me that, is that he was aware of that document. It's something that he knew that the government was doing on his behalf. If he's unaware of it, and it doesn't go to his bias or anything else, he has to be aware of the government. And yes, oh yeah, I was aware that they were trying to help me out.
He did say that. I can tell you that he was aware of that.
And I understand that, and the question is, was he aware of this document?
Those are two different questions.
Okay.
This document incorporates the effort that he was aware of. It corroborates the effort.
Let's find the testimony concerning the document, and it'll make it a whole lot easier for me.
I'm sorry,
It
Judge?
would be towards the end of Bruno's cross.
Right where you looked at W
Okay.
is where he's going to have marked it. And Judge, while you're at it, you might as well look at X and Y as well.
Okay.
W, X, and Y are the document that we're talking about now, and then two letters by Mr. Sortino to, I guess, INS or ICE or somebody, and to United States Immigration. And specifically, my recollection is, and you'll find it in a second, Mr. D'Souza said, all this stuff went through my attorney. I didn't see any of it. I don't know anything about it.
Okay, let me find the documents, and then we will go from there.
You guys, please give CJL a warm welcome. This is a new friend that I met yesterday on a Disney stream. We had so much fun. I forgot to tell you guys. So it was on Scuda Adventures. Scuda used to be a cast member at Disney, and he goes around on a scooter, and I use a scooter when I go to Universal, and I've not needed, back when I used to go to Disney, I didn't need a scooter, and I haven't been back since I use scooters now. So I've been watching his videos, and he did a live stream yesterday, and I mentioned that I had not been to Galaxy's Edge yet, so he gave me a personal tour of Galaxy's Edge, and he goes, let's go see if we can get some stormtroopers to mess with us. And they were out, and Kylo Ren was out too, and it was amazing because Kylo Ren, he looked at Scuda and he saw the phone and he goes, what are you doing with that data pad? Are you sending transmissions to the Resistance? He was looking like he was right in the camera. I was so excited that I cried. I was like, thank you so much. That was awesome.
Well, Mr. D'Souza testified that he was familiar with the contents of the document. He did that on page 3290 of the transcript. He remembers getting the document. He doesn't remember when he got it. His lawyer gave it to him at the immigration building. I'm paraphrasing. I'm sort of going through the testimony. So he's familiar with it. That goes to possible bias. So clearly W is going to be admissible. X is a two-page letter.
From Mr. Sortino.
All right.
As with Y.
Give us a second. And it was shown to the jury. X was. He wasn't sure that he was familiar with the document, but he was familiar with the efforts of the prosecution to keep him in the United States.
You're at 3304, Judge?
I'm at 3298 right now.
Okay.
And he indicated he asked his lawyer to ask the prosecutors to see if they could write a letter to get his sister and mother into the country. And he was asked questions about how he felt about that. Okay, now we're going to why. Now he says he's not familiar with why. He is, however, familiar, he did know that his lawyer told him that the prosecutors were working on a change in his status. And he was aware that the prosecution was trying to help him. Do you wish? It sounds to me like this corroborates basically that he was aware of the efforts. One of the exhibits, he was aware of the letter itself. Others, if he wasn't aware of the letter, he was aware his lawyers had talked to him about it, told him what was being done on his behalf, and basically that goes to his bias.
My position
Any
is
possible bias.
I have absolutely no problem with those arguments. The problem is with these letters, he didn't draft the letters. We didn't hear from the lawyer who drafted the letters. We didn't hear from the lawyer to whom the letters were drafted or the Immigration Naturalization Service that received the letter. I mean, it's one thing to ask him.
Oh, it's okay. That's strike two.
Strike one.
With a cookie fryer.
I mean, yeah, it's right.
This carries definitely.
I don't know,
That's count one for the fire.
And for instance, Judge, we talked about this for the people, the CDC thing.
Right.
It's fine for me to argue that, and I can argue what Dr. DeMaio did or didn't think about the statistics, et cetera, but this document doesn't come in because I didn't have a member of the CDC who actually drafted this who could establish the accuracy of it. There are specific things in the letter for which Mr. D'Souza could never argue the accuracy. He certainly can, the argument can still be made by Mr. Brunon or Mr. Rosen, whomever, that, look, he was aware that certain steps were being taken by the prosecutor's office, et cetera, but the contents of the letters, there's no foundation for it. I mean, I couldn't even lay a foundation for it. I work in the same division as the guy who wrote the letter.
It's not being offered for the truth of the matter, Your Honor. It's being offered for his state of mind and to corroborate his belief that efforts were being made. The district attorney's office could have written to the INS that Mr. D'Souza is a Heisman Trophy winner and is eligible for the Nobel Prize in testifying. Neither of those facts would be true.
Yeah, Brunon says that every time that they argue hearsay. He says, but it's not being offered for the truth of the matter asserted. Yeah, you use that argument every time. That doesn't work for every time it's hearsay, dude.
True, but if Mr. D'Souza believed that those representations and those efforts were being made in his behalf, it would go to the question of his motive or bias to favor that side, and it would corroborate the other matter that the court just mentioned a moment ago.
We're going to break for lunch. I'm going to consider that on his reasoning. I'll admonish myself, and we'll come back at 1:30. Okay?
This is the funniest judge. I love this judge so much. He's going to admonish himself for agreeing with Brunon. I love it. Okay, now they're fixing to put somebody on the stand. Whose lawyer was what originally? I don't follow, Flash. You know whose lawyer that was originally? Whose lawyer was what originally? Which lawyer was whose?
All right, we're back on the record.
When the court left the bench this morning, we were discussing the letter.
Who? Brunon, whose lawyer was he?
I wanted to draw the court's attention to two passages in the transcript of Mr. D'Souza.
Okay.
One appearing on 3298 at lines 8 through 10. Mr. D'Souza indicated with regard to Exhibit X, I don't think I've ever seen that letter before today. With regard to letter Y on page 31 at lines 22 through 26, I've not seen this letter from Mr. Sortino to the Immigration Service asking him to get permission. He had never. My argument would simply be we don't even know if the letters that are presented are the same letters that were actually sent or not. The point that Mr. Brunon wanted to make
Sorry, guys. StreamYard is being finicky again. He was Ozil's lawyer? No way. Oh, well, I like him even less now.
Mr. D'Souza may have felt like he had gotten from the prosecution is made through oral testimony. These letters are not relevant to his testimony. He had never seen them before. He doesn't even know if these are the same letters that were sent. There's no foundation for them. So I would leave that with the court as to whether or not he had testified to the substance of the letters. He very clearly, as I reviewed his testimony, indicated, I've never seen those letters before.
Well, I don't think it's relevant whether or not he saw the letters. He expressed a subjective awareness of the letters. He knew that the prosecution was trying to assist him with INS. He knew through conversations with his attorney that letters and other actions were being taken. These letters embody the actions that he believed were being taken. Jackson is suggesting that these letters are not the actual letters written by Mr. Sortino. They were produced by the prosecution for prosecution file. So I assume they're authentic in that sense.
Just because he knew they were helping him out with immigration doesn't mean he knew exactly what they were doing to help him. He didn't necessarily know about any letters or what actions they were taking. He did testify that they were doing something to help him with his immigration status because he was cooperating and helping with the case. That doesn't mean he knew every single letter that they wrote or whatever, though. Is that what he's trying to argue? That he knew every single letter that was written on his behalf to immigration?
And again, we're not offering him to prove that he is a material witness, that the prosecution working on behalf. We're corroborating his, that to his knowledge, in his behalf, to not only have him remain in the country, to have his work status adjusted and to make arrangements for his family to come up here. All of these things were benefits that he had requested, either directly or indirectly through his attorney. That's why they're relevant. And if we don't, and then it's going to suggest to the jury that they didn't really exist when we all know they did, and he was examined upon them.
There's a couple of Supreme Court cases. One, I don't have the cites. PG&E versus Thomas Drage, D-R-A-Y-A-G-E, and Rigging Company, and also People versus Maki, M-I-K-I. And although these are not directly on point, the Thomas Drage case talks about it had to do with automotive repair bills, but bottom line, the Supreme Court found that it could be used as corroboration where there's other testimony that supports it, and there is. In this case, we do know that certain things were done on his behalf. I mean, the people really can't take a position that Mr. Sorrentino didn't write the letter.
That's not the position.
And I understand that.
I just want to make it clear.
And when what the import of that case was there's testimony, the person is either aware of them or something. In other words, here he's aware things are being done for him. This is corroboration that things in fact were done for him. So on that basis, I'm going to admit those exhibits.
X and Y.
Okay, what's next?
Z.
No objection to Z through
Okay.
E2. Our next objection would be F2.
Okay, F2 is a weapon fired from the Spitz book. Okay, I remember the picture.
Up here, Your Honor.
I know that's the one.
Right, there are a couple of photographs like this, F2 and G2. We simply want to lodge an objection that these are not indicative of the actual gun. In this case, they were testified to with regard to GSR in general. I have no problem with that. For these actually to be admitted and go to the jury could be misleading. They may suggest that this old-fashioned cowboy gun is indicative of the exact type of GSR or a smokeless powder or whatever that's indicated in the firing of the Colt Cobra. That's simply not true.
Well, I think there was adequate testimony to support that where that was differentiated, and I think that's in the record, and certainly that can be argued. The objection is overruled.
We have no objection. I'm incorrect. H2 and I2. I have to look at those real quick. Judge, you'll see and we can probably address a lot of these in one fell swoop. With regard to the coroner's data sheets, the 42s that have been testified to by Dr. Pena having been filled out, you'll see that in I2 as opposed to H2. We have a strong objection to the VAT, for instance, is a perfect example of that material coming in before the jurors. This is rife with hearsay. This is not a business record insofar as business records are defined by the evidence code. This is a form and it's blank. If the court can imagine glancing up at that document and the only thing on it, it says worksheet on the top and it says 42 in the upper left-hand corner, and that's it. It's no different than this pad that I use every day. Mine just doesn't have the number 42 on it, and my notes and my thoughts are put down on this during the course of the trial. The 42 is what Dr. Pena chooses to put his thoughts down on. They are hearsay. They are not part of a form that you fill out, or say, for instance, the 20 is very different. An anatomical diagram. You see a consistency with objections throughout this. We have diagrams. Diagrams are illustrative evidence as long as there is a foundation laid for them. 42s, and there's tons of them. The defense marked thing under the sun, tons and tons and tons of these 42s. They're hearsay, and they're not. There's no exception to the hearsay doctrine. Even if he testified to them and he was shown them, to go into nothing more than take hearsay statements that are handwritten out and putting them before the jurors. I have the same objection with H2 as well. I don't believe that any foundation was laid that that's a business record as suggested by the evidence code. So I know that's a long objection, but I want the court to know what each one of these, why I'm objecting to each one of these.
Okay.
This, along with many other like it, were objected to when they came in before the court allowed me to publish them. I had to lay a very strict foundation as to a business record. I think the court made inquiries too as to a number of these documents. the reason that this document is relevant is this is the business record he kept when he went to the scene. It's in the part of the coroner's official file. Indicates it, and I believe Dr. Pena testifying determined that it was a homicide before he did the autopsy. It's noted in here, and he acknowledged that. This corroborates that he actually put that in writing as part of the official coroner's file. So we think it has all of those relevancy tendencies. It gives the times and so forth, and we think it is a business record that the foundation was laid as to each and every one of them over strenuous objection at the time. And we think the jury should see sort of the process of the victim as to how Dr. Pena did his job. Certainly, I don't see any prejudice to the people. Typically, it's the defense that doesn't want all this redundant information in, but we think it really helps amplify and explain our case and our theory of our case.
Mr. Jackson, is there some prejudice you want to point out?
The only thing I would, Judge, there's so much of it, I'd have to start looking through each document of it. The hearsay rule doesn't require prejudice. There's an evidentiary standard before stuff is admitted. And one of the things that the defense has consistently confused in their arguments is they say, well, I'll say hearsay. Corroboration relates to relevance. It is relevant because it corroborates something. It's relevant that I stand out in the hall and, say X, Y, Z to Roger, but that may not be admissible because it's hearsay. We have to play by the rules, and I don't have to show a prejudice before the hearsay doctrine is invoked. My point is I don't want the evidence code to kind of fly away because the defense consistently says, well, it's corroboration. It's corroboration.
No, I understand that. Was the witness questioned about these documents?
I think he was questioned about either all of them or most of them. At some point, I remember Mr. Ford, so I would imagine he's pretty thorough. He didn't walk up and ask Dr. Pena, is this your handwriting? Did you write in blank? Yeah, and all that testimony is there, and they can argue it all they want to. My problem is the evidence code, a strict interpretation of it indicates that this document doesn't come before the jurors. That doesn't hinder the defense's arguments that, for instance, on one of his 42s, Dr. Pena indicated that he said that she died of a gunshot wound to the head and that the mode of death was homicide. They can argue that. That document, however, I don't believe is appropriately published to the jury to go into the deliberation room.
What foundation was laid at the time the documents were discussed with Dr. Pena?
That these are notes that was that addressed to me, Judge?
Anyone.
My understanding, and Mr. Plord can probably expound on this, the foundation was that these are in fact his notes. These are his handwriting. These were during the course of his litigation at various times, either in a meeting, meetings with Dr. Lakshmanan, notes to himself after the autopsy, before he got certain other evidence, after he got certain other evidence, after speaking with so-and-so, he'd just grab a 42, a blank 42. They're literally on a sheet like this. I mean, 42s come on a sheet like this, and you just keep tearing them off. And he would write notes to himself. So the foundation is that they're his. I'm not objecting to that.
Are they required to be, I'm asking, at the time he testified, did he indicate there's a requirement if he takes these notes that they be part of the file?
Is that there is no requirement that he take the notes, but notes that he takes on the 42, he, as a matter of course, puts them in the file. Absolutely. I mean, he doesn't take them home and stick them in his glove compartment. These go in the file.
And I think he also added on cross-examination by Mr. Plord that they were accurate, they were made at and near the time of the event, and that he kept them in the customary scope and course of his duties and obligations as the coroner. I believe that was in there also.
Volume 22, page 38, 23, we went through basically two business record exception in detail with reference to all the notes, and then also the past recollection recorded to how he took particular notes. So I think they qualify both. But in particular, the business exception where he testifies that your business records, these are part of the official coroner's file, et cetera, et cetera. Each and every one was on into. There was objections at the time, so we went through them in detail, and I had to lay a foundation before I could publish any one of them.
Why would they not be then business or records?
Because the data on, at least my understanding about business records, is that the data on the records have to come from a source. For instance, when you're a 911 operator and you're taking down an incoming call, they will say, I am trained to take down what is being said, what pertinent information is being said to me. Therefore, the information that goes onto the form has an inherent trustworthiness that can be defined to a source. That source being whatever it is. If it's a DWP, your monthly water bill, for instance, Judge, that could be a business record. Why? Because your water bill is put down the same way off the meter, off the back of your house every single month. This is, the 42s that I have a problem with are a free flow of information that Dr. Pena thought out and just kind of interprets out. And they could have been in a meeting with Dr. Lakshmanan about whether or not to look at the box. And he indicated, I'm not going to look at the box, and Dr. Lakshmanan doesn't want me to look at the box. You know the box I'm talking about.
I understand, but if he basically, and I'm relying on what Mr. Plord just said, if he testified that he took them down, he was accurate when he took them down, it seems to me there's your inherent, how does this differ than any other business record?
Well,
It's his own thought process. What's more, it's not filtering through another person, which still would be admissible under the business records exception, but he's saying, this is what I was thinking, this is what I was doing.
I guess the difference, I may be making a difference without a distinction. I'm not being very convincing, obviously.
No.
In my mind, it's somewhat, there is a great distinction between, for instance, let's use the example I used a second ago, the 20, which is a diagram.
I understand.
And his notes. The 20 is done the same way every time he cuts open a corpse. Every single time. He looks at the head and he writes down his findings there. The 42, I guess I just look at it like whatever happens to be in his thought process at the time is what he thinks about. And if we're talking about accuracy, by the way, and the defense's position is these are accurate and they have inherent trustworthiness, that document that they just had on there indicated mode of death, homicide. So if the defense is conceding that the accurate mode of death is homicide, I guess I could withdraw my objection. I don't know that they're really going that far. So it seems to me there are things in there that are helpful, obviously, but there may be things in there that are not relevant and hearsay, and that's my position.
I hate to overrule your thought process, but I believe they qualify, the objections are overruled.
That's fine. Then that'll save us a lot of time with, there's a lot of these in here, so we can
Okay.
move on from those.
Tell me what your next objection is.
It would be Q2. Oh, no, I'm sorry, N2. N2?
Let me look.
Yeah, while he's doing that, could Mr. Dixon look through this just for one quick second on something?
Okay,
I know there's no jury, but you'll understand what I mean.
all right. All right, we're going to interrupt the exhibits to, I understand you have a witness you want to present on your motion for...
Yes, that's correct.
Okay, you may proceed.
P like in Paul, I-E, T like in Tom, R-A-N, T like in Tom, O-N-I.
Thank you, you may proceed.
Your Honor, I'm open-endedly, so we can get hopefully to the point. Detective, by whom are you employed?
City of Los Angeles, Los
what-
Angeles Police Department.
And what's your assignment?
I work the homicide special section of robbery homicide division.
And was that your employment and assignment in April of this year?
Yes, sir.
At that time, were you asked to participate in an investigation related to this case?
Yes.
And what were you asked to do?
I was asked to act as an intermediary and go and interview a possible witness and report back to a special master.
Okay. And who asked you to do that?
I was directed by my captain, Captain Kyle Jackson.
Did Captain Jackson tell you who had been in contact with him to seek this assistance?
No, he did not.
Okay. Did you receive any additional direction other than what you've just said? Well, strike that. Let me start over. What was your specific assignment to do?
Well, a person was identified to us, a Professor Lori Levinson from Loyola Law School, and it was explained that she was going to act as a special master. And an individual's identity was given to us, and we were told that we would eventually report to her what information he had to give.
Okay. And is this information still coming from Captain Jackson?
No, I believe I ended up contacting Professor Levinson
Okay.
to determine the specifics and to ask her for some direction as to how she wanted it done.
Okay. And what did she tell you?
My initial conversation with her, obviously I introduced myself to her, explained to her that I had not been in this situation before, and asked her for direction. She told me that my partner and I would go and meet with this individual who was identified as Gregory Diamond, and that we would determine if he had any information to give. We'd collect that information, report back to her, and that she would make a determination as to whether she would meet with him.
Was the subject matter of your inquiry described for you?
Pardon me, sir?
The subject that you were going to be inquiring about, did somebody give you a description of that?
All I was told was that an individual by the name of Gregory Diamond claimed to have information relating to this investigation, this trial, and that we were going to go and interview him to see what information he actually had.
So I take it that before the first time you saw Mr. Diamond, the scope of the inquiry hadn't been narrowed to a particular incident or a particular event occurring at a time. It was just find out what information he has about this matter?
I had no information regarding that. I don't know if anyone else had received information.
Okay. Your partner was Detective Moberly, is that right?
Yes, sir, that's correct.
And did he participate in the same conversation you had with Professor Levinson?
No, I spoke to Professor Levinson directly.
Okay. And did Moberly tell you that he'd received any directions from any other source prior to the first conversation you had with Mr. Diamond?
No, he did not.
Okay. So was it your intent when you saw Mr. Diamond simply to ask him, what did you know about the incident, and then report back to Professor Levinson?
Yes.
Okay. Now, up until that point, had you spoken to anybody in the district attorney's office?
No.
To meet at law school campus, is that right?
No.
Where did you meet with him?
We met at the Newport Beach Public Library.
Okay. And at that time, you made general inquiries of him, of his former employment with the Shapiro law firm, is that right?
I don't know whether he responded as a result of a question we asked, but ultimately that information came out.
And during the course of the interview, did you ask questions about a meeting that had taken place with Mr. Shapiro and other people that you believed were involved with the defense team? I'm talking about Dr. Bodden, other attorneys, that sort of thing.
Objection, Your Honor. I mean, we don't want to hear stuff that we've gone and made great efforts to avoid hearing, so.
I'm going to allow, that question doesn't quite get there, and we're all on guard for just that eventuality.
Okay. I'm cognizant of that, Your Honor.
Okay.
What is the reason for this question, for this witness? I missed it, I guess.
Questions about those meetings, or that meeting at any event.
As I remember, we responded to information that Gregory was giving us. We would ask questions, but ultimately we did not receive any specific information.
Prior to that interview, had anyone instructed you not to inquire about communications between the lawyer and the client, or the lawyer and the other, I'm going to call them, if I say team members, so you know what I'm driving? Dr. Bodden, the other lawyers that were present, the paralegals. If I call that the team, would you understand that?
Yes, I understand that.
Okay. And had anybody instructed you not to ask about communications between the team members?
The only specific instructions that I recall were those coming from Professor Levinson, and that was to go interview Gregory and find out what information he had.
Just a moment.
You may.
Your Honor, I don't require. I'm sorry, one last question. You concluded your someone else?
Yes.
To whom? Report to Okay, I don't have anything else, Your Honor.
Thank you.
Just a couple
cross-examination.
I just want to clear up the time sequence, if I could. So your captain, Kyle Jackson, informed you that you were going to have this assignment, correct?
Yes.
He was very vague about what the assignment was.
Correct.
Part of the or that she would contact you.
I don't recall getting any specific direction to contact Professor Levinson. I contacted Professor Levinson for lack of information to find out what she wanted us to do.
And did you do that before you talked with Greg Diamond or had the interview with Greg Diamond at the Newport Public Library?
Yes.
So there's no question that the sequence here, you get the information or the assignment from your captain. At some point, you talk to Professor Levinson, correct?
I talked to Professor Levinson immediately after getting the information from my captain.
And then she gave you certain directions, and it was after that that you talked to Greg Diamond in Newport Beach.
That's correct.
Thank you. Nothing further.
Thank you. Redirect. All right, you may step down. Thank you for being here. Yes, he can be excused. Any other witnesses?
Sure.
Any witnesses the prosecution wants to present?
No, we're in the dark on this to this great degree. Yesterday, this outrageous conduct that the allegation was made, and the witness has now left the room, that somehow the police detectives went and talked to Greg Diamond without any instructions. Clearly, that's not the case.
Okay. Well, do you have any other witnesses you want to present?
No, Your Honor.
Okay, do you want to argue?
Just briefly, the instructions are adequate, but they weren't been done by the prosecution.
Based upon that, the motion, since it's pending, and if you don't want to withdraw it, I'll deny it. There's inadequate facts to support that anything was done improperly. Let me just say, we've probably gone over several times, and actually Ms. Kenny Bodden sort of indicated yesterday, well, you let Mr. Diamond testify, you haven't let us do anything. Well, of course, you've been able to procure any witness that you wanted or do anything you wanted. What I said was, initially, that the motion on its face, because all it had were these, they didn't go anywhere. They weren't even done under a declaration. They weren't done under examination. So now, at least as all the evidence that's been presented to me, what you have is, just to reiterate, this individual, who it turns out is working for Mr. Shapiro, contacts the district attorney and says, I have information about the case you want, or you would be interested in. The people recognizing, because of his employment, and I believe he identified himself as to what his job was at the time, very quickly say, we're not going to deal with this. We can't. They do the smartest thing they can, and I'm obviously adding my interpretation. They go and ask me to appoint a special master, which is exactly the right thing to do, because a special master works as a intermediary who is not going to give information to the district attorney if anything is unearthed that would be of a privileged nature. Now, I've been thinking about this, and we all sort of assumed, based upon now unsupported allegations, as to what the detective may have said to Mr. Diamond, but truthfully, at this point, we don't know. We know that there's a danger of privileged information, but certainly the detectives or Professor Levinson do not know what the information is. It may be privileged, it may not be privileged. As it turns out, some of the things in the way of observations turned out not to be privileged. They examine them, they report to Professor Levinson, she reports to me, and we've gone on the record any number of times, Professor Levinson and I agree, stay away from anything that's privileged. Nobody wants to know, nobody has a right to know. It's for whatever reason that Mr. Diamond came forward. But in the investigation, it turns out that he made certain observations that Professor Levinson inquired me, and we both agreed, Professor Levinson and I, did not appear to be covered by any privilege. And as we now know, by what's agreed in the Court of Appeals, we were correct. They were not privileged. They weren't covered by the privilege, and we have taken that as far as it went with Mr. Diamond's observations of certain things, and then that led to Sarah Kaplan, and then ultimately it was her observations that became admissible and relevant to this case. So as far as any outrageous government conduct, it's non-existent. So the motion is denied.
That's fine. I don't want to argue that any
Okay.
further. But what was troubling about this to us was two aspects of it. One of them was, and I'll represent this to the court, and I don't think, well, people wouldn't have grounds to dispute it, but we can lodge with the court under seal, if you like, a transcript of this initial interview. And it did focus on confidential communication, so that was obviously troubling. The other thing was that the defense was totally excluded from the process, and we're the ones with our client, Mr. Spector, is the one with the entire stake in the action. We felt it would have been appropriate to, particularly since it was on the
Wait, are they saying that the Gregory Diamond thing was the basis for their motion on prosecutorial misconduct? That was not prosecutorial misconduct. That was some dude coming forward saying he saw what he saw, and it had nothing to do with the prosecution. The prosecution just put him out there because he saw what he saw. And I don't want to talk about that stupid fingernail again, but I'm just saying that was not prosecutorial misconduct. Jeez. I know, right? It's not their fault.
to have all of this going on in the background put us at a disadvantage.
If anything, it's defense misconduct because they should have owned up about whatever Dr. Lee picked up and put in his pocket.
And it is to some extent still tainting our defense at this point. But having said that, in terms of proving that the prosecution or anybody else associated with them set an inappropriate course of action off, we haven't established that, and we've submitted it on what we did establish.
Okay, I appreciate that. My final comment will be the reason the defense wasn't included. This is basically what the prosecution is doing. They're investigating a case. Now, in the initial, they don't have to inform you until they have their facts before them as to we have a witness, we don't have a witness, we have inculpatory evidence, we have exculpatory evidence we have to turn over to you. The bottom line is until Mr. Diamond was investigated, you didn't have a right to know. It's someone who came to them as a witness, and the only reason the court was involved was in pointing the special master and making sure the special master was had some direction as to where she was going because of the nature of the privileged information. And as soon as the information became known and all the facts were known and it was reduced to a report, you were informed. And it was the timing was as the people got it, as the court got it from the special master, and that's why it happened the way it did. All right. With that in mind, that motion is denied. I don't think there are any other outstanding motions in this case. I think we have dealt with everything, every motion that was filed. If not, I'll consider it abandoned by either side because otherwise we need to get by it. Okay. Now, back to the evidence.
Into the section. Here's where we're at.
Okay.
This is the Alhambra Police Department major incident log. This is a part of the police report under the evidence code. It's simply not admissible as a police report.
I'll wait till counselor just...
I know, and that was crazy because he was the one that went to them and said, I saw this. But then when it came to testifying about it in court, he wanted no part of it. I was like, why'd you even come forward, dude? That's crazy. Did you want to tell him or not? Like, what's the deal here? But yeah, that was insane. Just like, dude, commit. Like, you started this, you can't back out now. But yeah, that was crazy that this dude went to law school and then what he saw made him not want to be a lawyer. That whole situation was just insane to me. But yeah, so I didn't realize they kept mentioning that there was a motion about prosecutorial misconduct. It never registered in my brain that it was about the Gregory Diamond situation. And the motion, I guess, was because they didn't know about it beforehand. Because and like Judge Fiddler just said, it was because the prosecution was investigating and they didn't have the right to know yet. So I guess they were saying that it should have been discovery. They should have been told about everything before Gregory Diamond just appeared out of nowhere. So, okay. So now all the pieces fit. I understand the motion for prosecutorial misconduct or whatever it was called. I know. And you know, I don't blame Judge Fiddler because if he thought that the fact that it was televised had anything to do with the hung jury, and maybe that's the same reason why the second Menendez trial wasn't televised. Maybe maybe that's why California doesn't televise anymore. Maybe they think that the hung jury had something to do with it being televised. And I don't know if that's true. That's just my weird brain going there because and maybe it's just a coincidence that the first trials were televised and they got hung juries and the second trials weren't. That could be a total coincidence. But in my head, there are no coincidences. And that's just what I think. So, I don't know.
And two.
And two,
Which is the list of crime scene law.
is the
Yes.
crime scene law.
Right.
Speaking of in and out.
It's the in and out log, and I think it's relevant because it shows the number of people that were in and out of the crime scene. A lot of testimony about all of that and what effect it may or may not have. And so I think this is the actual log that's kept as a record. By number of witnesses.
And
I think that, I'm sorry.
I thought it was established as a business record, and certainly the relevance is to show the number of people that came onto the scene, which is an issue.
And whether or not the scene was contaminated in the foyer.
Right, that's the argument that's going to be made from that.
Well, there's two things about that. Number one, once again, I didn't argue that it's not relevant.
Okay.
The issue is relevant as to who came and who went. This is part of a police report. Police reports are not allowed. This is kept in the regular course of keeping a police report. Not a hospital record, not another business record, a police report. Police reports aren't admissible. They never have been. I mean, otherwise...
Portions of, no, that's too broad a statement. Portions of police reports can be admissible. If it's done with an eye towards litigation, it's not. I don't believe that's a correct. If you want to show me a case that says no portion of a police report is ever admissible, I think that's incorrect. We can I'll put a little mark around that.
Asterisk.
I think I can resolve that pretty quickly because I don't think that's the law. But if you find a case or something, that's fine.
The second thing is, I would argue that this is, as I just heard counsel argue, that they're going to use this to establish how the crime scene was contaminated. They're talking about the foyer. And this is not an entry log into the foyer. This is an entry log into the crime scene, which is down at the bottom of Alhambra. I'm sorry, down at the bottom of Grandview. So it should not be used in a misleading fashion if, in fact, the defense wants to use this to establish how many people came on the property. That's one thing. To argue that this is indicative of how many people were in the foyer under 352.
Wasn't the judge on the second trial? I thought he was the judge for both trials.
That would be, I think this is misleading.
Don't forget who has the last argument.
That's a good point, Judge.
Okay.
All right. We'll look for, I'll look for that. I think there's something in the evidence code concerning police reports, but we'll get to that in a minute. My next objection, Judge, if you want to jump to Q2. Actually, Q2, yes.
Okay.
That is same objection I had previously with regard to the Spitz book diagrams.
Okay.
This is not the actual gun. It's misleading. It's not, we have no idea how the Colt Cobra reacted in this particular issue. I'll submit.
Same ruling, it's admissible.
Okay, if we jump to V as in Victor, to the second.
Okay. Document dates 2590.
And I've already submitted my arguments for this. This is out of a sex assault kit. I believe it contains, I'll submit.
Same rulings, it's admissible. I think
With
you
regard to
F3?
C3, actually,
You say you agree.
correct, they are withdrawing that. We have
Okay.
no objection to them.
C3 is being withdrawn?
Yes, Your Honor.
Okay, C3 is not being offered in evidence would be more appropriate, all right?
But you know what, Judge? Hang on just a second.
Sure.
I changed my mind.
Okay,
I took this out in anticipation of the rest of the 42s not being in. I didn't feel like it was fair for me to want this and not the rest of it. So since the court has ruled that the others, a foundation has been laid for the others, I think this is admissible as well.
Okay.
Sorry about that.
no problem.
No, they wanted it, I guess that's fine.
Okay.
Okay,
The next one we come to is
Excuse me, I'm sorry. That's it.
that's in.
Okay.
F3. I'll overrule myself. That's going to come in.
F3, okay. F3 is in.
G3, Judge.
It says agree.
Same thing.
Okay, same ruling in. I3, there's an
I'm
objection.
sorry, my mistake. G3, if I can speak for the defense, I believe G3.
Oh, they're not offering it.
Correct. I don't think they were offering it.
We are not offering that.
All right, G3 is not offered.
Can I take a quick glance at this?
Sure.
I'm sorry.
Absolutely.
Given some of these, the autopsy things, we made our objections based on previous objections, so if I
Yeah,
can.
just for the record, the reason we didn't offer this is that basically the typed up version.
That's right.
This is just a handwritten that was typed up, it's just duplicative.
That's right. It is. It's exactly
Okay.
duplicative, so I don't necessarily need this.
So G3 is not offered. All right, H3, medical history.
We're offering.
Yes, we are.
Yes, there's an objection.
It needs to be redacted, this certain portions, but,
Who's medical history of,
Lana Clarkson.
this is a form that she filled out in, it looks like mid-01, when she saw Dr. Batra, B-A-T-R-A, Batra maybe, and
And it has to be something that you would be in trouble with the law for. Like, if they asked you a question about, like, were you sleeping with so-and-so, you can't say, I plead the fifth. Like, if you're under oath and you get asked a question that isn't going to put you in jail, you can't plead the fifth. You have to answer. It can't just be oh, it's none of your business, so I plead the fifth. You have, which is what a lot of people do. And then the judge will say, you can't plead the fifth. You have to answer the question. I always get tickled when people do that. I yell at the screen, no, you can't do that, because that won't put you in jail. You can't plead the fifth for that. That's not a crime. That's just TMI.
it basically gives her history regarding headaches, about bleeding, etc. This is a form that's filled out by Miss Clarkson, kind of a doctor's, fill out these forms before you see the doctor thing. Going through it very fast, but it gives sort of her rendition of her medications. There are certain things that she talks about coughing up blood. She talks about having medical problems, including bleeding, etc. And we're going through it so fast. Okay, let's start with the second page. Medications, headaches, headache medications, and then the next page, just a list of nothing. Can't see if there's anything objectionable there.
When did Furman take? He took the fifth? I haven't gotten that far in the. Well, no, when he testified, okay, I'm watching the trial. Granted, I've missed a bunch, but I'm watching the trial on Court Vibes channel in the morning. And when he testified the first time, he didn't take the fifth. I've not gotten to whenever they call him back where they play that tape where he did the racial slurs. Is that when he takes the fifth? He could have been charged with perjury though. Because when he took the stand the first time in that trial, he said he had never in his life ever made never in his life had he ever made a racial slur. And he never said the N-word ever. And then they found this tape of him doing just that. So, yeah, he could have gone to jail for perjury. Because earlier in the trial, yeah, he took the stand in the trial too. And I think he took it twice. I'm not that far yet. But he must have taken it again. Because I know they played the tape of all those racial slurs. Because I watched plenty of movies and documentaries and stuff. And I know that happened. And now I'm watching the actual trial. But like I said, I missed a bunch. But the first time he was on the stand, they did not play that tape. They just asked him if he'd ever made any racial slurs. And he said no. But I have heard the tape, like on documentaries and stuff, and I know that he did. So the only reason I can think of for him to plead the fifth is because he would have been held, he would have been charged with perjury because he'd already gotten up during the trial. Yeah, that's what I've always heard too. But how does that happen when you have a jury of 12 people that are deciding? I've always heard that too. But I think that's just a rumor. Unless they had a plant on the jury. Oh, you think the jury just came up with that on their own? Because they were mostly African American? I don't know.
We've deleted a certain portion of it. And then we get into prior doctors, other than serious headache problems, etc. And then basically this shows us a long history of it. Started at least in 01, and then it goes on through 02. And then there was one other problem that was with this. I can't remember what it was. It ties in the Long's Pharmacy records, and it talks about, go to the next page, the multiple checks, frequent headaches, 4 checks, and then other maladies, and then also there's one that talks, I think the next page talks about the bleeding disorder.
One of the things I think we should be sensitive to, given the fact that this is on television, this is televised,
right.
A lot of this stuff is not, there are some extraordinarily sensitive things in some of these medical records. I haven't objected while Mr. Plord makes his offer of proof. The long and short of it is these are Botcher's records. Botcher didn't testify. There's no foundation to these medical records. There are foundations to other medical records to which we had stipulated there is no foundation to these, plain and simple. There are also extraordinarily sensitive things on these records like what's on the board right now, and I'd appreciate being taken down immediately, that are obviously extraordinarily prejudicial. Under 352, this court would never allow this kind of stuff in, and it's rife through here. So, on one hand, I can appreciate the offer of proof that we're all trying to make convenient for the court. On the other hand, with regard to the medical records, I would appreciate it if counsel would work with me to be a little bit sensitive about these things. For instance, displaying that on the...
Okay, I think, is this thing we've talked about before?
No.
Oh,
Different stuff.
I thought, no, we did. There were
there were certain areas that we weren't going to get into. We'll redact the records according to the court's rulings. I don't have a
The
problem.
bottom line is, why isn't it a statement of her then existing physical state if it's relevant to what happened? In other words, it's her, in her own writing. I think everyone's familiar with the writing. It's a statement of her then, what she perceives to be her then existing physical state. And then the question becomes, is it relevant to the issues in this case? And certainly some of them are. So part of it would be admissible without any other. You don't need the doctor to testify. If the handwriting, everyone's satisfied it's her handwriting, she's basically saying, this is the way I feel, this is what I suffer from.
And we subpoenaed the doctor's records, and we get an affidavit of the custodian that's as part of his medical file. So I think it's part of that medical record of Lana Clarkson. And there is no question as to the authenticity of that. We just need to clean it up, is our position.
Well, then we're in the position of, I mean, this may be the, and I understand if it is, if the court has taken a position that if she wrote something.
Did you talk to Lana Clarkson? I'm using an example, yes. Did she tell you how she felt? Yes. What did she say? A, B, C, D, E. The only question then becomes, are those items relevant to this case? Merely stating your physical condition does not become relevant if it doesn't have something to do with this case, but several of these things do. And what Mr. Port is indicating, they do need to be redacted. There are items in there that are not relevant to this case, but once redacted, it seems to me they would be admissible. If you can't agree as to how to redact them, then you need to come to me to get a ruling.
If that's the court's ruling.
That's my ruling, but
that's fine.
if the parties can't agree, then you let me know.
And Mr. Port, on the Batra records, you're aware of the sensitive issues that we want redacted.
I will propose a redacted version to you.
Next, Your Honor, and I'm curious about this. I would ask if Mr. Rosen or whoever is the proponent of these is seeking the admission of I to the third.
Well, I think that's been made before. I mean, I sort of ruled it was inadmissible.
Right.
We're calling it Lana's life story. That's
Right.
the document.
I'm curious why that was not withdrawn.
Well, they may be protecting their record.
Consistency, we believe that, and we're going to ask the court to reconsider its ruling, given all the testimony. We believe that there's certain portions of the record of that story that should come in, given all the evidence that came in our case.
My same ruling. One, we don't. There are certain events that clearly relate to items that have been testified to, but we. This is part fiction, part truth, embellished, not embellished. It appears that the last piece, prior to, many years prior to her death, I think I cut it off at 88 or 89, and I did that based upon the last entry, and she was talking about a movie she had made, and we were able to date the movie. For all those reasons, there's all sorts of problems with this. It's different than the emails. It doesn't qualify. We don't know what the basis of this was, so therefore, court is finding it's inadmissible. Okay? I mean, we've had a lot of J3 will not be admitted.
J3, Your Honor, is a coroner's inventory dealing with medications.
It's part of the coroner's file?
That's correct. It's from the Department of Coroner. I don't remember, quite frankly, if Barbara Nelson laid the foundation for this or not. I know that Barbara Nelson testified. If she did, I'll withdraw it. I just can't remember it.
It's in. K3, redact. K3 is in, but it needs to be redacted.
That's correct, with only the relevant admissible medicines.
Okay?
Yeah, Mike, how do they propose to redact? We'll work it
The
out.
two of you will sit together and see if you can agree, and if you can't, you come to me and I'll make a decision.
L3, we're seeking not to offer.
Okay, L3 will not be offered. Do you want to check?
May I take just a quick
Sure.
glance at this? It's hard for me to see it. Can't read. I need to see the actual document.
Our vote is different.
Let me make this larger.
This is the note.
We're offering it, Your Honor. I'm sorry.
This is
The exhibit in my
L3?
book is not the correct exhibit.
Okay, so you're offering L3?
Yes.
What is L3?
L3 is a note that Dr. Pena testified to that he took of a conversation he had with Donna Clarkson within a few days of the death of Lana Clarkson, where he talked about her being depressed over the holidays. He said that was maybe the year before, and that she was a waitress at the House of Blues. No psychiatric history. That's that little scribble. And referred to and said that Dr. Batra was the doctor, and I think I just redacted the phone number, and that's Dr. Pena's signature. He talked about that at length as being the only history he ever got regarding her psychological state of mind, etc.
Okay.
My objections would be multiple levels of hearsay, notwithstanding that this is on a 42 down, not under penalty of perjury, from Donna Clarkson, not under penalty of perjury, referring to a Gopal Batra, which is a third level of hearsay, not under penalty of perjury.
I'm going to sustain the objection as this one. This is not reliable because it is based on hearsay. It is total hearsay. There's no, so I'm going to keep this document out. Whatever testimony he testified to concerning that, obviously that's in. Testimony is testimony.
I think you pretty much read the whole thing, too.
Well, then you're free to go ahead and basically, if the transcript supports it, you're free to argue. Frankly, this evidence, it's not my job to say, and because I thought about that a lot this morning before we started, is that there are so many levels that so much of this evidence has come into. A lot of this really becomes technical arguments. The truth is the evidence is in front of the jury, but I'm going to keep this document out.
I'm sure you will.
Okay? You're free to argue whatever Dr. Pena testified as to it. If he did, if it came in over objection or without objection, then it's admissible. Just the document itself. Okay?
That's fine. I think that takes us to M3.
Yes.
It's a 42.
Same objection to this 42.
Same rule, and that's N3 we're talking about?
M3, M as in Mary.
Okay. So that's admissible.
Then N3, as I have it, is another letter dated March 21st of 05 from Doug Sortino.
This is the letter, Judge, to remind you that
Are we on now 03?
we are on N as in Nancy 3.
I have coroner's notes on mine. N3 says Bates 3978, 3979, coroner's notes. That's on your...
Correct. It notes it's actually the correct Bates page numbers, but it's a letter to the coroner's office.
From Mr. Sorrentino.
Correct. Sortino shot a letter off to Dr. Lakshmanan with an inventory of the box that he was sending him. That's what this letter is. Once again, it's hearsay. Nobody has testified to the accuracy of this, what was in this box, what was in the containment that Dr. King never looked at, that Dr. Lakshmanan never looked at, just put in his office and locked up. It has never been seen since. This has absolutely no relevance to anything because nobody's ever seen what's in the box. So the letter has no relevance.
That's what's relevant.
That's what the point is that the DA takes over their investigation, gives them a box full of investigative materials that they just don't even look at. And we think that goes to the weight and the credibility of the expert opinions from the coroner.
Except for the fact that you gotta cross some evidentiary bridges. You gotta have Dr. Doug Sortino testify to what he sent Dr. Lakshmanan, and they didn't. They could have called him. They didn't want Doug
No,
Sortino.
what they're arguing, in essence, what they're trying to articulate, this is being offered for non-hearsay grounds. It's the mere fact that it was sent. They want to argue that the DA took over the coroner's investigation and tainted it, if you will. That's what they've tried to establish through witnesses. It's not the truth of the letter, it's the fact that the letter that provides some, from their standpoint, some argument.
Okay.
It becomes non-hearsay.
I understand that. But there has to be a foundation for the letter, Judge. They had to have called, the defense just mark anything that they want to mark. They didn't call Lakshmanan, they didn't call Doug Sortino. Had they done that, objecting.
Okay.
But they didn't do it.
Was there any witness that testified to preparing the letter and sending it?
Yeah.
No.
The objection is sustained.
03, Your Honor, is the same thing. It's a different letter sent at a different time, but the exact same objections apply. Doug Judge Sortino didn't establish the preparation of this particular letter either. And Dr. Lakshmanan didn't indicate the receipt of this letter.
Yeah, but
Yes, Mr.
Judge, it really doesn't matter who sent it. If somebody snuck in and got to Doug Sortino's computer and composed this letter and somehow got his signature on it, would be interesting. I don't think anybody thinks that's what happened. It is, as the court said before, it's the influence of the prosecution upon the coroner's office that's relevant. In the other instance, the fact that a bunch of stuff was sent over there but not looked at, that's the relevant fact. If there was nothing in the box, there was that's what the relevant is, not what actually was in the box. And this is the same situation that they're talking about, a psychological autopsy. It doesn't matter what the source of the information is. We're not offering it for the truth per se. We're offering it for the influence on the investigation.
And I understand that gets you by the hearsay objection. It doesn't get you by the foundation objection. Had Judge Sortino been called, did you send this letter? And you know, if you said yes, and then there were objections after that or whatever, you get past the hearsay grounds. I don't have a problem with the hearsay objection.
It's part of the coroner's file. I think we did have a foundation that it was sent, well, it was received by the coroner, put in Lana Clarkson file. In other words, it's part of that, their record there. Now, did we have Judge Sortino testify? No, we didn't, but I think that gets us, to the point where, okay, circumstantially it appears the letter was sent, put in Lana Clarkson's file. People treated it as a publication or as a letter from, the prosecutor on the case, which I think the court can take judicial notice of, on official stationery, and it ends up in the coroner's file in the correspondence section regarding this particular case, and it deals with case numbers and coroner's case numbers and so forth. And Dr. Green said, yeah, that was in the file. So we'll leave it at that. I think that's probably enough to get by our foundational requirement.
The file was written by the district attorney, but that it was considered to have been written by the district attorney by the people who received it. Foundation normally goes to the authenticity and accuracy of the contents, and that's a hearsay concept. That's not why we're offering this. We're offering it to show that the coroner's office believed that this was sent by the district attorney's office, and that's the foundational fact we did establish.
And then circumstantially, all the people that are named in the letter are witnesses that the jury's heard of. At least a lot of them are.
Well, to some degree, the letter is self-authenticating.
Right.
We know who the players are. I don't think the district attorney is making the contention that this was not sent by the district attorney's office. I'm satisfied for the purpose that it's being offered and the purpose it's being used. It's admissible. The objection is overruled.
Thank you.
Is that true for the prior one?
Yes, and that means I changed my ruling as to M3.
Thank you.
I know you're not happy, Mr. Jackson, but that's the way I analyze it.
I understand, Judge. I'm not trying to.
No, it's fine.
I'm just thinking of legal arguments. I mean, it seems to me that the defense's argument.
Well, you think about it tonight and come in, and if everybody can revisit some of these if you think you find a case. I mean, obviously, I do this on the fly.
Sure,
based on
I understand.
my knowledge and experience, and if you come up with something specifically that says I can't, I'm happy to look at it from either side.
Don't take my deep sigh as frustration with you. We've been together a long time. I'm not taking issue with you, Judge. I'm trying to think of these novel defense arguments that hey, look, wink, wink, nod, nod. We all know where this stuff comes from.
No, but that's actually a very good argument. I mean, it
obviously, it convinced you. I'm not taking issue with that. The point is, I guess I am sort of a stickler with the evidence code. That's fine.
I agree. I agree that I am not, if I don't believe it qualifies under the evidence code, I don't make up my own exceptions. But there are lots of, exceptions, and you have to sort of think, why is it being offered? What's the use? Who testified to it? What are the facts about this? And bottom line, again, I don't think there's an exhibit, maybe with the exception of Lana's life story, because that had a lot of, if you will, inflammatory matters in it that is going to change one thing in this case. Now, I can't read the jury's mind, and none of us can, and I could easily be mistaken. I don't think there's very much crucial. When I say crucial, it's important to your arguments and to support. The jury is well aware of all the facts in this case. They're just waiting to have it sort of put into context through argument, but there's nothing of a shocking nature here.
I'll leave the court with a single thought.
Okay.
I would ask the court to inquire of the defense if their recollection is that Dr. Pena said he ever even saw the letters, because he was shown both of them.
Right.
Did you ever even see these letters? Did you know they were written? His answer was no.
Why don't you take a look?
One of them, he said that, I know, even though it said CC Louis Pena, but there was testimony that was part of the coroner's file. I do remember that. And he did talk about the box being sent over to Dr. Lakshman, but he was told, I don't want you to look at it, and he testified.
Again, the important is that the box was sent over. It's for their argument. If you can specific, let me know. Perhaps it may of the letters would not be admissible. We're on to P3.
Your Honor, P3 is it's a printout of
Lana's treatments.
certain.
I know what it is. It's a SAG insurance record authorizing psychological treatment. It was subpoenaed, and the custodian returned an affidavit showing that it was part of their business records. And basically, the next page is the area of inquiry. This is in 1994, so it's a bit remote, but it shows that she was being treated for a particular condition. Dr. Pena reviewed this, testified about it. It was an anxiety disorder. He explained what that was. But the treatment goals is why we wanted to have it admitted. Basically, the goal was to, quote, get over not having a father, not crying all the time, end quote. And we believe, based on other witnesses, that Lana was crying all the time. This shows sort of a history of this now, and it's not just an isolated incident. Because this goes back to '94, where she's getting some type of psychological treatment for not crying all the time. And now we have, a number of years later, 8, 9 years later, where she's still having the same problem. Now, did she have it all the time? No. The evidence is the evidence.
Sounds like it's a great argument for the people, with all due respect, that she has crying jags and she doesn't. I mean, if you want it in, and you want it out, up to you. You folks make your decisions. I'll rule on it.
I understand the court's ruling, but my position is this is remote. It's 1994, unless the defense is going to argue.
The question is, did Dr. Pena testify to this document specifically, that he used it in any way, fashion, not that it's part? What did he testify to about the document?
Yeah, he said he considered it. He didn't give it much weight, et cetera, et cetera. He didn't put much stock in it at all.
If Dr. Pena considered it, then it's admissible.
I agree. I think Dr. Pena considered it when Mr. Clord showed it to him.
No.
I believe
Wait, don't talk over each other.
Sent to him it was one of the few things that was sent to him by the district attorney's office and so forth. It's not something I showed to him first time. He said he had received this, and he actually talked about it, et cetera, and he basically said didn't change his view of things because he got it within the months before trial.
Okay.
I'll withdraw. We'll keep it in.
Fine.
We'll keep it in.
Okay. Objection it's received.
When I said withdraw, for the record, I meant withdraw the objection.
R3.
R3, which is a Bates email. Bates stamp. It's email.
Right.
I keep looking at who's this guy Bates that testified now.
This is the bookmark of the depression on her computer at a certain date and time. And this is a defined to where basically Lana Clarkson, and we know the date, 6902, is the date for the RSVP for the advertisement for the SAG depression, alcohol screening, and so forth. And it was referred to on a bookmark. I'm not sure what that really means computer-wise, but there was a lot of testimony about this, how it got on her computer, what whether it was an email or whatever. Frankly, after the testimony, we think it has some relevance, but not as much as we first thought.
Mr. Plord and I have talked about this many times, and he gets this wrong every time. This is not a bookmark that Lana Clarkson put on her computer. When you go back to your computer,
I remember the testimony now.
The foyer, the computer guy, did a search, and he happened to call the search Clarkson depression references. This is totally misleading, and he was asked on cross-examination and direct and reiterated this.
She would get things because
mass emails.
Mass email. The objection is sustained.
Thank you.
All right, I remember this now.
The next one, Mr. Rosen, what is it, T3?
Let's check here. T3 is the next one.
It was our, you know what, I think I may have I don't think I had anything on C3.
This is an email to Peter.
Right, I think this may be a mistake on my part. Let me glance at this.
Okay. You know, she gets rested, doing fine. Even if she does keep changing her appearance. Are you on the run? Are you a fugitive of some kind?
What was that movie that David Jansen starred in?
That's just... That's a mistake, Judge. I shouldn't have...
Okay, the objection is withdrawn. T3 is received. There's a W3 needs to be redacted.
That's right. There are, for the reasons that we've
There's
talked
a problem, come see me.
Line 3, Your Honor, is Ms. Clarkson's date book, and it looks like it's almost the entirety of a date book. The problem I have is relevancy. Only the page or the pages that Mr. Plord deems applicable and has had a foundation laid for. For instance, Bainbridge, that
Right.
entry would be fine, but this entire thing I think is overbroad.
Well, the defense needs to get down to the pages they want on Y3, and then we'll see. But the whole day planner or day runner obviously is not admissible. It has inadmissible because it has inadmissible items in it.
Okay. So we'll indicate redact on...
Redact on Y3, okay. Same as the W3.
Okay?
Z3 is, these are hospital record nurse entries,
Right.
is it? Oh, let me put it on the order.
Okay.
These were testified to by... Just look.
Happy birthday!
These are medical records that were testified by the Sinai custodian, etc. They're basically records of her hospital course of treatment, prescriptions that were given, nothing regarding the infamous fall and breaking of the wrists. Quite a bit about.
Yeah, let's come.
It shows that she's being given medications.
Phone that's ringing?
Pardon?
Is it? Oh, okay. Anyway, go ahead, I'm sorry.
Yeah, and these are authenticated by a business, hospital record custodian. So
And the relevance is, for these, what's the relevant portions?
the times that she's in the hospital, the fact that she's been given Paxil shows on one.
Congrats on another trip around the sun. I know, right? Dude, where were you? We missed you. That was something, huh? What was the deal? I don't get it. Did they not think that a parent could possibly do that to their child or what? It was on video. On video. And they still found them not guilty. Crazy. We missed you though, dude. We really did.
Anything else? And there was testimony by Dr. Pena as to that too, also.
As to this particular document?
Yes, it was. I think we showed him this document, and he acknowledged that she received. I'm pretty sure that he.
Not pretty sure.
I think he was cross-examined. I'll get the page here.
Okay.
And our objection would be that Mr. Plord said that there was a custodian who testified to the foundation of the
No, we have an affidavit from the custodian.
I'm sorry?
An affidavit.
In other words, we did a subpoena, and it was returned with it's part of a packet of records from.
With a certification.
Right, Right, and then I think Mr. Rosen, later on, we got the custodian to testify to certain other records from that pack too, but they're all the same records.
Well, that may be. They may have gotten an affidavit for a subpoena ducis tecum. That's not admissible in, that affidavit doesn't make it admissible in court for
Well, no,
foundational purposes.
I think the affidavit is to circumvent if it qualifies under the statute that deals with that, so you don't have the custodian come in and testify because the affidavit takes care of that foundational requirement.
Similar to the phone lines.
Well, are you looking for your reference to Dr. Pena having testified to this? And what year is this from?
This is the Cedar Sinai Hospital records for Christmas 2001. It's when she was admitted to the hospital for a broken wrist.
Okay.
That hospital stayed.
My broken wrist is so important. Just lost a little bit of work. Broken wrist. I don't see it's relevant.
Page 4185, where it starts and then it goes on. We've talked about that subject for a couple of pages now.
My dad called, you know that word that we can't say, we always say unalive themselves? My dad called it sideways? Sidewise? Committing sidewise. He called it committed sidewise. Yeah. He committed sidewise. That's what my dad said. So now it's sidewise. That's what we're going to call it on this channel. Sidewise. So I've been out of work since 2010. I can't work. I don't want to commit sidewise. Not at all. And I have been very, very, well, when I was very, very ill, I did want to commit sidewise. But I didn't actually want to do it. I thought that I wanted to, but I never went through with it. But I had cancer. I didn't have just broken wrists. I still don't see what the relevance is, though. I really, really, really don't. Because that happened in 2001. That was 2 years before her death. So why would she wait till 2 years later? They were healed by 2 years later. But they keep talking about her broken wrists. I don't see the relevance. That's 2 years before. It's I don't know.
Actually, that's just that's part of the longest records. I'll have to get that.
Okay, at this time, this Z3 is provisionally, the objection is sustained. If you can show me where it was tied into testimony, then I will reconsider it.
Your Honor, with regard to B4, this is relatively simple. All I'm concerned about, I object to the last sentence in the email. It's salacious. It's not relevant to anything. This is a letter to Hugo Quackenbush. I would simply ask that the defense redact the last sentence. And if they don't want to, then explain why that's relevant.
Are we talking about B4 or C4?
B4.
I'm sorry.
Does it mean something bad? Well, then maybe I shouldn't use that. Well, then never mind. We'll just keep going with unaliving yourself.
No.
I'm sorry.
B4.
The objection is to B4 on your
Objection
sheet,
is to B4, which is a 42.
but C4 indicates that it's a letter to Hugo.
That's what I'm saying. I'm confused because he's talking about the letter and the one that says objection on the sheet is B4.
Mr. Rosen, let us find out if it's got the right.
I'm with you, Judge.
Okay.
I see. It's actually, I believe it's actually A4.
A4?
There is
That's listed as Lana's loan agreement.
Correct, but there's a letter associated with it or attached with it. The letter that came with it, and the last sentence of the actual narrative of the letter, Mr. Rosen, is what I'm concerned about. Otherwise, I don't care.
Last sentence.
Mr. Rosen actually read this from beginning to end, I think.
I'm sure he did.
But there was something at the end, I can't remember.
I'm looking at the last sentence, and it says, you also agree that this...
Don't read it out loud.
Again, don't read it. Okay.
Well, why don't you give that to
Well,
us?
someone's going to need to show it to me.
Okay.
Yeah, the court needs to see it.
All right, bring it up. Yes. Oh, that's absolutely, what's the relevance to this case? Mr. Ford's trying to come up with one.
I'm thinking it. Well, no, I'm trying to read it. It's so slow. Who Hugo was an older gentleman that
Yes.
Clarkson had a relationship with. She borrowed a lot of money from.
Yes.
No doubt. And basically, I think that the way she got that money is really exemplifying that last paragraph. I'll be honest, that's exactly what was going on. And she's the one that, and Hugo is also the person through another letter that she's sending the false letters to.
I understand that.
And basically, at the end, I think Hugo is not happy with her, and that, I think, contributes to issues related to her state of mind. That's the best argument I can make.
Not bad for thinking on your feet, however, the last paragraph will be redacted.
Thank you, Judge.
Okay, that's A. Now what about,
That's
Now-
B4, right?
no, that's A4.
A4, B4 will withdraw our objection based, actually, I want to interpose the objection, but I understand what the court's ruling is.
Okay,
It's 42.
so that's,
B4 is Data's brother. I'm sorry. Every time they say B4, I think of Star Trek. It's Data's brother is B4.
B4 will be received.
And we can jump all the way down to K5, so
Okay?
we're actually making some progress.
K5, it says keep, I guess the defense
means-
is not offering it, the prosecution wants, it's a photo of the front side of a gun.
Yeah, we're seeking to withdraw.
And it's this photo, the foundation of which has been laid by Lynn Harold.
Okay, that's the serrated ramp of the gun.
Correct.
We have a different photo, Your Honor.
Okay?
Let me...
We're good.
Which one is right? This one?
This is right now.
This is right.
We want this in.
We want this in.
Okay, so that's in. Okay, K5 is in. L5, there's an agreement that it will not be offered. Document from Renteria's notes.
That's correct. There's
Okay,
absolutely.
L5 is not being offered in evidence.
Okay.
R5, a photo of a barrel gun is not being offered in evidence, but now the prosecution wants it in.
Hold on a second.
Certainly.
I'm sorry, some of the exhibits that were given to me don't match up.
This is how you begin to find out, Mr.
Yeah.
Rosen. This is,
Well, it's only been 5 months, Your Honor.
okay.
We're on K. R5.
Mr. Brunon is preparing to make the final argument. These are just subtle little notes to you.
R5 we're not offering.
You're not offering.
Not offering.
But the people want it.
Correct.
Yeah, I don't think we brought this up. I'm not sure. At least that was my recollection. That's why we withdrew it.
That's a shot taken looking down the rifling of the barrel, Judge, with a little bit of unburnt or burnt smokeless powder in the barrel.
Who testified to it?
I believe Lynn Harold did.
See, that's why we withdrew it. We marked it, and we never got into it with it. I actually marked this with a different witness, with Mr. Renteria, and I didn't use it, and that's why we withdrew it. And I don't believe that Lynn Harold used this photograph anyway.
What I need to do is, at this point, it is withdrawn. However, if the people can show me where they can link it to testimony, then I will change my ruling to admit it.
Sure.
That's fine, too.
Okay?
Your Honor, I think not admitted is at the moment rather than withdrawn.
Right, I'm sorry. They're not, right. When I say withdrawn, what I'm really meaning it's not being offered in evidence. I'm sort of using them interchangeably. And so right now, it's not being offered, but if the people can show the link, then I will admit it into evidence. The next is X5.
And we're not offering that.
People.
And we would seek to have that admitted. The statue in this area of the foyer is,
Again, the only question I had, did somebody testify to it?
I don't know that somebody testified to this exhibit, but there was testimony about, I believe, the statue being tipped over.
Right, there's a lot of testimony regarding the statute, so we don't really object to it.
All right, X5 will be admitted.
That takes us to the next one.
Wi-Fi photo of chair from back right.
This one I know we didn't have testimony on, so that's why we're not offering it.
Okay?
Your Honor, this is a,
And I think the people had one that's almost identical to it that they're putting in their case, and so that's why we feel it's just duplicative, but if they want it in, that's fine too.
you know, quite frankly, there's so many pictures testified to. I can't remember if someone testified to this picture, but it's very obviously Lana Clarkson as she lay in state after she was shot, before her body was moved, before the chair was moved, and it shows blood dripping down the right side of the chair.
Prosecution, I think, introduced an exhibit identical with the ruler and with the blood, what would appear to be on the seat of the chair below the elbow, the right elbow.
Well, if somebody, I realize it may show something, if nobody testified to it, however, I'm sure there are other pictures. Until you can link it up to me, then it will not be admitted.
Okay.
If you can show me the linkage that someone testified to that photograph, that's fine. Next would be the defense is not offering it, the prosecution wants it in. Yes.
I thought this was objected to by the people, and we basically didn't proceed it. It's the cover sheet was kit from Mr. Spector. The court disallowed it before.
Okay.
Actually, it was Bob Middleburg. I asked him about this document on cross-examination. It had been previously marked. I don't know if it had been shown to anybody or not. Kerry Caruso actually wrote it. But Bob Middleburg, I asked him if there was a suggestion that Mr. Spector urinated before he gave his sample. Would that count as voiding? Is that basically voiding the bladder? He said, it depends, and gave me a long-winded answer. But this is the document that I used, and this document does, in fact, show that he urinated.
Was there, Mr. Port, you're indicating there was a sustained objection?
When we tried to get into it with other witnesses, it was...
That may be, but the question is, at some point, was it admitted?
No, the Middleburg just said this was provided to him as an expert, and he did... I do remember that testimony that Mr. Jackson just mentioned. But
There was only form based on this, in other words.
No, he said it. He didn't agree with Mr. Jackson's proffer. So,
Dr. Pena didn't agree with half the stuff Mr. Flores showed him, but all that stuff's coming in too.
what does it say about voiding or going? Basically, this is a sexual assault standard OCJP form. It's a government form saying, okay, did you go to the bathroom? Did you wash your hands? It's all information from Mr. Spector that was objected to. Okay.
I understand that, but what did I rule when you made the objection?
That when we tried to get it in, you ruled it couldn't come in. It was hearsay, et cetera. But when Mr. Middleburg was, I don't know if it was published to the jury at the time, but Mr. Jackson did ask questions about it. Were you given this?
Mr. Jackson, you need to find the area where you asked questions concerning this, and I would like to know what the rulings were when he was, I want to take a look at it and see what the basis of it was and why it was used, and then I'll make a determination. So for the time being, C6 is not admitted subject to the people linking it up.
Okay, very good.
L6 and M6 are not being admitted by agreement.
That takes us to Q6.
Okay. Q6, parties are not admitting by agreement. V6 is being objected to from the principles of bloodstain analysis.
Can we have 1 second?
Sure.
Did you take G?
No, V6.
I think there was testimony regarding that, what it means that this is what Stuart James and other people, and also Mr. Pat.
I remember Mr. James testifying about the pattern and also the hole from the bullet.
And then I think Dr. Harold also was shown this, and there was issues with this back spatter, forward spatter, and it was explained. That's right.
It absolutely was, and every expert said that is not indicative of the pattern in this case. That's completely misleading. That's shooting into a sponge, which Mr. James indicated. I think James and Kish did this experiment, and that is not indicative of the backspatter pattern that you'd have in this case.
But it was shown to witnesses. The witnesses did testify to it. The fact that ultimately the weight may be useless because of just the reason you stated, it still is admissible. It goes to the weight the jury will give it when you point out in your arguments, folks, we're not talking about sponges. But people said, yes, this is what it shows, this is what it does. And then to say it's a sponge, so it's not a live experiment or whatever, so therefore it's not admissible, I don't believe that's a basis for objecting. Witnesses did testify to this as to how they used it or didn't use it or why it's relevant or not relevant, but...
Well, I guess my point would be if they testified that, yes, I used this in coming to a conclusion or opinion, yes, I used that document because it's indicative of what we have here. Yes, I use that because that helps us get to a final conclusion in this case. That's one thing. But I could show the witness this and say, do you see this in my hand? Yes, I do. Does this mean anything to you? And does it have anything to do with this case? No. That doesn't make that admissible. They were shown this in an effort, I think, by the defense, because I can guarantee you if this comes in, everybody hide and watch, somebody's going to stand up and say, this is what you'd expect to see on Phil Spector's jacket. And this is not what...
And there would be an enormous objection which would be sustained.
It would be an enormous objection.
That was clear from the testimony that this was done a certain way. It's not meant to replicate what would happen or not happen, because, and frankly, nobody really knows. This is a sponge. It demonstrates what backspatter is under certain conditions.
And that's the reason why it's admissible. And again, its weight is minimal, but it is relevant. The objection is overruled.
Okay. Thank you, Judge.
Okay. So now we're down to A7, a hand-firing exemplar gun, which is being objected to.
Same. I have the same objection, and I think that's probably going to be the same ruling.
And the same ruling as A7 is admissible. B7 is CD.
That was Dr. Spitfire's weapon, which we've seen a number of times in testimony.
That's admissible. Why is it not, Mr. Jackson?
What, this?
C7, this B7, the CD. He's explained that he testified to it and what it meant, what he was doing.
Oh, okay. This is Spitz actually firing the gun.
Yeah.
My objection is...
Non-representative again.
Correct.
Different gun, different ammo.
I know, okay.
That's fine.
Thanks. All right. Next.
G7.
G7, the is not being moved, but the people want, it's Ms. Clarkson in the chair with taser, leads, and discs. Well, there's been lots of testimony concerning that.
There has.
We'll submit.
All right, then, G7 will be admitted over the defense objection, but on the motion of the prosecution. To H7 as a videotape.
Sorry, guys. I put the banner up and StreamYard glitched. You guys, don't forget to like the video, please. That helps me out. And lets more people find me. And I need more people to find me. Don't leave. Don't leave. I'm back. I'm back. Don't leave.
This indicated it's not supposed to be representative. It's just it's an animation. I'll withdraw my objection on that.
Okay. H7 is admitted. I7 is a CD of a CEG gun tutorial. GEG gun tutorial, pardon me.
I believe this is the same thing. It's the second of the two animations. I'll withdraw my objection on
Okay.
that as well.
I-7 is admitted, and J7 is CD Swade at,
It's actually supposed to be suicide.
It said suicide at PD. This is a CD that was never shown.
you're right, it's not admitted. The court is already, I'll note your request to put it in. The court kept it out. It was too prejudicial under 352 and did not establish anything that was not testified to by various witnesses, which had to do with movement after a traumatic head wound.
And Judge, before we move on, if the court has a pen and paper,
Oh, yes, we do get those.
at page 70, I'm sorry, at page 7701, lines 3 through 18, is my cross-examination of Robert Middleburg. Upon being shown a copy of the Kerry Caruso report, the urination report,
Right.
He does remember that it's one of the documents he reviewed. He talked about the highlighted portion called recent hygiene information, labeled urinated. The box isn't under a portion marked sample, it's under a portion marked recent hygiene information, et cetera, et cetera. So I believe he did testify.
Well, did he ultimately, however, he did testify, okay, but the bottom line is, based upon that testimony, did he do anything as opposed to, yes, I looked at the document, but did he rely on it? Did he use it? Did he interpret it? Did he factor it in? That's what I'm looking for.
I guess I would have to go to the actual transcript to see, because all I have here from my summary is he remembers it is one of the documents he reviewed. And if
Okay.
he reviewed that,
But
Before he
on
testified.
other grounds, because to a certain extent, I believe it was objected to on hearsay grounds, I'm not sure. I can't remember what your initial objections were when I kept it out on the defense case.
this may get us, I don't know if this gets us any
Okay.
closer or not. Witness says he isn't sure of whether that is consistent with Mr. Spector actually voiding before giving the sample, or if it refers to giving the sample itself. The box isn't under a portion marked sample. The witness cannot interpret the urinated box as it is checked here. The box recently urinated is marked yes. Recently defecated is marked no. Voiding just means going number one. I remember that part.
What Mr. Jackson was doing, he was trying to cross-examine Mr. Middleburg on the urine result, which didn't come in their case, saying that the urine result was X and that this was somehow a proper void for a urine collection, which Mr. Middleburg never said it was. And so it's sort of being bootstrapped in as maybe a...
Did anybody testify to how that document was checked, how it was prepared?
No.
No, we didn't call Kerry
Okay.
Caruso to the stand.
The objection is sustained, it's not coming in. I mean, you're not going to get it in, so that's, there we go.
I'm sorry.
That is,
That's
that,
C6, I believe.
C6 is not admitted. Okay, we're down to, let's see,
I think we're,
L7.
L7.
Photo of Lana and friends at dinner.
right.
It was,
Yes, it was testified to, it was described, she was identified by several people in this photo. I think Jennifer Hayes, Pumpkin Pie, L7.
what would the objection be?
Oh, this is a photograph of Lana with a bunch of people with her legs stuck up on the table. What does that have to do with anything, and how? Why is that?
Is this one that I let you mark, but I said I'll get to it when the time comes?
No, you vetted them, and I gave you a series, you vetted them, and you said this one was okay. You kept a bunch out, but this one you allowed.
This was shown to the jury.
This was shown to Daniel Stark. I mean, Daniel Stark was shown this photograph.
Okay.
With her leg on the table. It's pretty clear what this is being used for. And my objection is the same now as it was then. Why are they choosing this photograph over any other photograph to show to a firefighter who fixed her wrists, or says he fixed her wrists?
But did he identify it?
Yes, he absolutely.
You know,
Under 352, we are objecting to
Okay.
this photograph.
all right.
Identified, it's been testified to. I think
Yeah,
Jennifer
but
Hayes,
when you-
they mentioned, I think Pumpkin Pie even identified where that photo was taken.
Well, I'll tell you what, if Pumpkin Pie identified where that photo was taken, treated, this photograph really has no connection for the purpose of, it's not overly salacious, it is slightly salacious. There are pictures, as I have quoted or I have stated, you have your good photos, they have their bad photos. I think it's, some are needed for basic identification. Trust me, the jury's going to understand. I just say this, you do what you want with them, the jury's going to understand this. Don't underestimate your jurors.
No, and pumpkin pie is right in the middle of their,
Find whether or not pumpkin pie, just as the people would have me think it is, but I want to see whether or not pumpkin pie identified that particular photograph.
Looks like Mr. Gruden in the back there.
don't
I
answer.
think it was taken in San Francisco.
Pies testimony was.
Yeah, it's she's basically to just describe the photograph. There's a group of people obviously having to basically show on. You know what? I'm going to reconsider. It's going to come in. This is just not. It's not as bad as you think it is, Mr. Jackson. It's just there's no reason. It was identified. It can come in.
Okay.
And you know what? And you're free to argue whatever you want at the time comes, and both sides are free to argue whatever they want at the time comes.
Judge, I'll withdraw my objection to the next one. I don't think.
Okay, M7, the Brentwood Blondes program?
I think that was a mistake.
All right, then M7 is in.
That takes us to D8.
Right.
Kaplan drawing.
A foot on a table where people eat. Salacious or not, that's gross. The lady's name is Pumpkin Pie. Flash. She had it changed legally. It's Pumpkin Pie. Her name is Pumpkin Pie.
Oh, she described the fingernail.
Right, and the problem I've got with this is the drawing that she, sorry, the object that she drew on the thing. First of all, she qualified it by saying, well, Miss Bodman, I can't draw, and I can't draw it to scale. So she sketched this out and said, that's the best I can do. It's not to scale. It doesn't help anything. I mean, she described it orally or verbally, and she specifically indicated that this is not indicative. So I think it's...
Well, it's not for an artist rendition, and that clearly goes to me to the weight, not the admissibility. She was asked to if she could draw it. She drew it to the best of her ability, and you're free to point out the objection is overruled. D8 will be admitted.
And I think we go to...
F8, carpet, and I guess BS is bloodstain, I hope so.
It is. Yeah, it is. Carpet,
Because there's
yes.
never been anything else that would fit that description in this courtroom in the past.
Absolutely not.
Judge, if you want to take a look at...
It's up on the board.
Oh, good. Okay, 8 and 9 both. I'm sorry, D8 and E8 both.
Wait. I
No,
thought we were on
E-
F8.
We're on F8, and then there's G8 plaster on the carpet. Are those the ones you want me to look at?
Yes, Judge, sorry about
Okay,
that.
got it.
There's no foundation for either of those photos. I think Ms. Kaplan was shown both of them, and she specifically and roundly indicated she couldn't lay the foundation for them, and she didn't know. She said that she had never gone outside of the foyer area, which the carpet with the little white things, the plaster on it, was in a different area of the house, and she didn't see that.
Okay.
Please, as the plaster, that's correct. It's the previous one, I believe, that Detective Tomlin testified that that was the blood stain that was where the chair was, etc. So I think as to the former one, that was eventually sent. I think there was some testimony that was the one that was sent to the crime lab by Dr. Lee eventually.
If Detective Tomlin testified to that, I've got no problem. I don't remember him ever being shown this photograph.
Okay, you have, at this point, as to F8 and G8, the objections are sustained. However, as to F8, if you can show me testimony that Detective Tomlin as to that picture identified it, then I will reverse my ruling. Next would be I8, drawing of a jacket.
If I can have just a second, I'm looking at I and J. Our objections to these are both on hearsay grounds. These are, again, not part of the
No, StreamYard muted me. Can you hear me or am I still muted? I reloaded just to be on the safe side because StreamYard decided to mute me again. I don't know why. I hate it when it does that. It drives me crazy. Yeah, she changed it legally after she grew up. And her friends will refer to her as the pie sometimes. It's bizarre, but it's LA, so that explains it. Pumpkin Pie Laughlin is her name.
By them, did he not?
Both of them, he went through each.
Yeah, that goes to the weight again.
Okay, I'm not saying you didn't identify him, he did. I'm just saying it's...
That goes to the weight. The objections as to I-8 and J8 are overruled. They're admitted.
Judge, are we going to take a look at break?
Yeah, we need to. I don't even know if we're going to finish with the exhibits today. We'll try. All right, we'll do the best we can, and then I think we're going to end up working through Thursday on the instructions.
Judge, just before we break, could I just throw out a little brain teaser that we'll all need to think about for a minute? I was speaking with Mr. Jackson earlier this morning, and he told me that they intend at some point in their argument to show video clips what has been brought from the courtroom, and object to that because it's not evidence, it's not part of the record, it'll never be part of the record. I mean, there's several other levels of objection. For example, you're going to have to tell the jury they can't consider that as evidence, even though it's going to be a videotape of a witness testifying, that they'll have to rely upon the actual testimony. So it is a sui generis problem. I've had a related experience case here 20-some years ago, but it's not directly on point that went up and was ruled upon. But we're going to object to that, and we just wanted to have the court start to think about that.
All right, thanks. All right, we're in recess. It'll take about 10 minutes.
More exhibits. Jeez, this is taking forever. The Pie, coming soon to a theater near you. Since I've started watching Disney streamers, I have the weirdest stuff that comes up in my feed. Some chick tried to sneak in a Universal. She said, "My mother-in-law has my ticket." Yeah, that doesn't work. Nope. That doesn't work. Because they take payment out annual pass, and there's been times when it didn't go through, and I've gone to the park, and they're like, "Oh, sorry, your ticket's not good," and I'm like, "What?" Yeah, ticket in hand. Oh yes, I didn't know about it either, Flash. I watch them all the time. There are people that walk around Disney and live stream. They get paid to play at Disney World all day. I am so jealous. They are living my dream. If I lived in Orlando right now, this would be a completely different type of stream, I'm telling you.
I think Judge Warren just made another ruling. I'm not sure. Back on the record.
Thanks a lot when you're not around.
It's okay. That's good. Back on the record. Just, I wasn't able to find the case real quickly, but I have the concept in mind. The reason why sometimes it's not admissible is because the man has to his own observations. He has a duty to be accurate.
With regard to the...
This is the log.
The problem with that is, Judge, and I'm not being argumentative.
Okay. Yes,
Whatever
you
your
are.
ruling is your ruling. I'm being a little argumentative.
Okay.
There is a young whippersnapper that stands there with a pen in his hand and writes in Judge Fiddler in at 0800. Would you sign there, Judge? And then you sign. The officers don't fill out their own log. that they may jot their name in, but every one of those officers would have to have come in here and said, that is my portion, I filled it out, I came in at this time, I left at this time. Without that, you have, let's say their argument, 61 different individuals filling in a time with some young whippersnapper keeping control of this log. There is no, I mean, without the foundation for each one of those officers, that's where the trustworthiness is a little iffy. And I'll leave it at that.
See if there's any testimony concerning how the log was prepared.
I believe there was.
Well, you go find it. Moving right along.
Okay, Judge, the next one is, and I've gone through and tried to pull out, based on your rulings, I'm anticipating certain rulings, so I've tried to pull out some of my objections to speed this along. One that I
L8
can't
was
pull out is L8.
the red dress shot with lime and mouth.
Correct. Under 352, I don't see, how does that get us any closer to determining who fired the weapon on February 3rd, 2003? That is, I just don't believe that is an appropriate exhibit for the jurors. I objected to.
Same ruling. Okay.
We can move to,
08 is the next one.
It's the same Lana with the fork. Okay.
I withdrew it because I figured what your ruling was going to be, so I'll withdraw.
That takes us to Hewitt.
Okay.
And I'll withdraw that, as I think that's probably going to be allowed in as well.
Okay.
The next one, right.
Okay. All right. LA kicked it back.
I expected that Barry Fisher would testify. He was on the witness list. Miss Baden walked aside, talked to him. There was evidence of the foundation of.
I believe that Mr. Pex eventually testified to that, but I don't know if he used the exhibit or not.
Right. That was all right.
That was all right.
Right now, it's, the objection is overruled. Excuse me, the objection is sustained. It's not in evidence, subject to the defense finding some testimony that it correlates
We
to.
move to V8.
I'll withdraw objection to V8. I'll withdraw objection to W8 in anticipation of the court's rulings.
X8 is out by agreement or not being
Your Honor,
offered.
The X8, I believe, was testified to by Mr. Pex. This came out of his own book, and we want that, actually.
You want it, okay.
Yes. That's an applicable bloodstain, I think.
All right, you want to be heard?
Submit.
The X8 will be admitted.
And that takes us to Y8.
Y8, they have sought to withdraw that. We would ask for that. There was plenty of testimony as far as the leading edge of the cuff is
Oh,
concerned.
there's plenty of testimony.
I just didn't know whether we ever used this exhibit, so that's why
I believe it was used,
Okay.
but I'm going to admit it in any event. There's been lots of testimony to support the entrance of that exhibit. Next would be A9.
A9.
Extreme close-up of a jacket barrel.
Blood spattered, number 2, there's plenty to establish that is some 2 or 3 different magnifications come in.
Just for the record, we're seeking not to offer.
Right, and I will admit it based upon the people's motion.
Okay, Judge, I can probably save the court a lot of time with regard to
G9, which is the CV of Stuart James.
G9 is out.
is this out of order?
Okay, it's time to turn the camera off. I don't know why it does this.
Draw that objection.
Okay, N9 is received.
That takes us down to D9.
V9, the front of the defendant's jacket.
Okay, this is where I think I can save us some time.
Okay.
Judge, if the court looks at this particular document that is appropriate for argument, it is inappropriate for this particular exhibit to go into the jurors.
Okay.
This has hearsay statements that were made by counsel in anticipation outside the presence of the jury, not under penalty of perjury, along with the consultation of one or more of their experts. And I think it's perfectly appropriate and probably a pretty good exhibit for closing argument. This and the exhibits behind it, all of which have hearsay statements on it, no DNA transfer stain from left sleeve, et cetera, et cetera. Those are narrative of their interpretation. They only got through reading reports of our experts. So there's a couple of levels of hearsay, and this is narrative, and it's not under penalty of perjury.
Mr. James testified to this. He prepared this exhibit, and basically it's sort of a summary of his evaluation of this particular evidence. He looked at various things. Basically, he testified at length as to what he wants, and we feel that it puts there in one context. Some of it, I think, is actually, testimony like this stain was not collected. That's what the other witnesses. It's going to make a lot easier, but sure.
It's probably the comments I agree with Mr. Jackson's remarks. It's perfectly free to use it in an argument and to refer to an argument.
The court will take a look at W9, X9, Z9, A10, B10, C10, D10, E10, F10, G10. All of those are exactly the same. They're just different, same type of narrative.
And the same ruling. It's no problem with you using it as an exhibit, not an exhibit, as a visual aid during your argument if you choose to do so, but the comments make it inadmissible that are contained on the photograph. So based upon that, I'll just rule as follows, that basically W9, X9, Z9, A10, B10, C10, D10, E10, F10, G10,
What are you doing to me today, StreamYard? Will you please behave?
produce it and block it out to show them because it's not an exhibit, and I don't want the jurors looking at it for the exhibit. Sanitize it, redact it.
We'll do that.
If the court looks at
The next objection you have is I.
It froze for a minute, but sound should be back.
This is the one that should come in, and the other one should stay out.
F8 should be out.
Well, why is it doing that? Why are you guys looking at my avatar? And I'm looking at Judge Fiddler. Okay, Judge Fiddler's back. And Belle, you need to hush. And now it's buffering. Well, this was a good stream. Quit being wonky. This was a good stream. And as unexciting as this was, I was kind of enjoying the process because I've never seen this being done before.
was in one of the envelopes.
That's correct, but we don't know where that came from.
Well-
There's no foundation for it.
And that's why we were offering I-10. I think the court should revisit it because
No, but the bottom line is, without Dr. Lee's testimony, if you will, is what's important. It's absent. Okay? The objections to I and J tests are sustained.
Mary can. Judge, I won't spend a lot of time on these. These are M and N are the gun and bullets that Warner Spitz used
Right.
to fire the whatchamacallit, the demonstration. We think obviously this is a little bit confusing. It looks exactly like the Colt Cobra. It's not the Colt Cobra issue. I don't think that these.
we're not offering them.
There's an agreement that they not come in.
Oh,
We're not offering them.
But a good argument, Mr. Jackson. No problem with that. The M10 and N10 are not admitted. Next would be O10, red wax square with impressions and a ruler.
and that has, I'll just object on relevance grounds. There's no relevance.
This is actually shows the length of the site or the width of the site.
Right. The objection's overruled. Next is P10 GSR on paper.
This is going to be the same type of objection. This was taken at 2 inches and shows the.
Right, but I remember the
Stop it. Why do you keep doing that?
On to that result.
I remember there being testimony concerning this exhibit.
Yeah, there we had to redact the pictures. So we could-
Right. The objection to this is overruled. Next would be S10.
Judge, I'm confused.
Okay.
Are we all in agreement that this is the blood drop that was supposedly recovered by Dr. Lee off the stairwell?
I'm confused too. I seem to feel
Oh,
it.
they're about this charge. Don't be confused.
Okay, maybe-
This went on with the Henry Lee blood came from.
This was testified to by Mark Taylor as to this result, and he used the top line is the known profile of Lana Clarkson, and the bottom one is the drop that he got. And Dr. Harrell talked about the drop. She said presumably was a drop in the banister. Mr. Reddy testified to that.
Okay, we have a difference of opinion. What?
There's not a difference of opinion.
Okay, then I'm confused.
Mr. Taylor did say I did a DNA result.
Okay.
And I objected at the time.
Okay.
There's no relevance to this particular DNA analysis because we don't know where the drop came from.
I see what you're saying.
I was still expecting Henry Lee to come in and say, I found this drop, sent it to the crime lab, and we did a split. This is right out of the...
There was, I recall discussing this at this time, but Dr. Harrell testified without a question it was the drop on the stair.
No, absolutely did not.
She agreed that she received this, like I-10. It was received sheriff's office, but there's no foundation laid as to where they received it from.
Can we just take it under submission?
Yes,
Because of Harold's testimony?
what I'm going to do, I'm going to tentatively sustain the objection, but it is subject to being overruled if you present me testimony as to the foundation. Not that someone testified about it, but that it has some relevance because someone can say, this is where this drop came from, and therefore tie it to something specific.
Understood.
Okay.
So conditionally overruled.
Conditionally grant the objection is sustained until you, as the proponent of the object, convince me that there is testimony tying in where it was recovered from.
Judge, this takes us to S10, which has already been ruled on. These are 11 photographs of Lana Clarkson in different acting roles.
Right.
With guns, and the court has ruled.
Yes, and that,
We continue our preservation of the record.
the objection to S10 is sustained. T10, Lana Clarkson email, rate depression.
This is the same type of thing. If you look at the upper left-hand corner, the Clarkson depression reference is from Fortier. This is not. This was not generated by Lana Clarkson. This was generated by Fortier, and that's.
Are you objecting to the way it's labeled or the content?
The computer content that is gibberish.
This testimony.
Yeah, I don't think anybody on the jury speaks gibberish.
We have a gibberish interpreter.
Waiting in the hall.
That's right.
If we just take the label that they put on off, would that satisfy?
Well, that's what I was at, Mr. Jackson. Is there anything in there that is admissible?
I guess I'm looking to see if that is. Yeah, Jen, can you make that bigger? Yeah. I think all of this is contained in the emails.
Right. The emails themselves are already in evidence. It's the heading that's the problem, and it's not admissible.
Same for U10, Judge.
Same ruling.
And then
I think there were parts of it that I thought were totally irrelevant, but there may be parts that are admissible. Was there any testimony?
The court indicates it's going to redact a few of the portions.
Right. Well, I think the redactions are obvious.
We'll submit a redacted version.
Submit a redacted version. I'll take a look at it.
May I clarify something with Mr. Plord?
Certainly.
Is this a one-page document?
No, it's a multi-5-page. It was one that with one of the witnesses. It was the opening.
Okay. Did this have, without getting into the content of it, Mr. Plord, did this have the list of things?
Yeah.
Yes.
Okay. That is obviously the portions that we're very concerned about redacting.
Okay.
Okay.
I think I'll submit a redacted version.
Thank you.
That's not a problem.
Okay.
White 10.
Okay.
White 10.
Next one would be B11, C11. Oh, I'm sorry, just B11. This is an email.
Actually, we withdraw the objection to B10.
Well, no, the B11 is what we're on.
I'm sorry, B11.
B11 is received then. Okay. All right. Then I have two objections to two exhibits that aren't marked. This is object.
Actually, that is all within
It's all within
D11. It's
Okay.
multi-page document.
Okay, so we're not talking about D11?
It's all within.
I asked you how you wanted it, you said mark it just as B11.
Okay. So now your particular objections are to,
I think we can withdraw this. Withdraw the objection.
all right. D11 is received. E11. Object to the C.
It had some discussion about procedure cyanide document that as to the accuracy of what is contained in it. Under past medical history, it indicates significant for migraine headaches and some depression. However, we do know that when she went to the hospital, one of the medications she put down was Paxil. We also know, doctor, nurse, whomever, I have chronic headaches. This indicates significant for migraine headaches and some depression. What we never heard from, or what we knowing that she took Paxil, wrote some depression, because Paxil is classically given for depression rather than headaches, although in this case it was given for headaches. Or if Lana Clarkson said some depression. That was the foundational kind of disjoint that we had at the beginning, and when I objected first, and we still have it. They've rested their case, and they never put a witness on to establish this information came directly from Lana Clarkson, and it's not an interpolation of her statements and the medications that she was on, or vice versa.
I
think it's
suppose that
confusing.
exists in any medical record, that is it the doctor interpreting it, or is it what the patient is saying? I think this qualifies. The nurse testified to...
Nurse Rosenfield did.
Yeah, the foundation. The objection is overruled. You can argue that. but
Okay.
the bottom line is it's admissible.
M11.
M11, color copies of letters to NBC, Fox, and Showtime.
We only say that's duplicative of the F11.
The colored copies were the ones that, we didn't have them at the time we marked the
So
black and white exhibit.
Would you like to withdraw then F11 and just go with the color copies, M11?
Yes.
All right, evidence is what not, and then into then as a rule.
N11 is duplicative, Judge, of the jacket.
To rely upon.
But again, the same problem with what's printed on it, therefore you can use it in your argument if you want, but the objection is sustained.
Okay.
Next would be U11, 4 emails with Eric Porticha.
May I have just a second?
Sure.
I'll withdraw. I don't know why I objected.
Okay, the objection is overruled. U11 is admitted. W11, the defense did not wish to admit, but the prosecution is asking that it come in. That's close-up of Lana Clarkson's jacket sleeve and button.
This actual photo was used with Dr. Bodden.
Oh, there was, I remember, yes, I remember the testimony. The objection is, the people's motion to admit it is granted, so W11 is received.
And that takes us to X11, and
CV of John Andrews, offer of proof there's an agreement that it not come in.
We never got to that with the witnesses in front of it.
never.
I don't believe he talked to you. His CV was actually introduced in evidence. There's an objection to Y11, the width of the spinal cord chart.
This lacks foundation. It physically, like specifically, was testified by Dr. Spitz as being wrong. He agreed that he was wrong about the internal bore of the gun. He did a little mathematical thing. Jim, do you have this, or should I put it on the...
I don't have it.
Okay, let me...
No, he testified as in the measurement, and he explained it. And this is right. And they use bore diameter, there's a lot of testimony about might that be a variance or whatever, but basically he said that that's the standardized chart for it, and that he compared what Dr. Andrews testified about to the actual what he calculated. It's just what he said versus what I believe is the case. And the critical thing is that he actually measured the width of the spinal cord, as opposed to what Dr. Andrews did, is took a general measurement from some article.
The point is, very clearly in cross-examination. Remember when I said, are you aware of the difference between a bore diameter? And he said, oh yeah, that's right. I said, do you agree with me that 38 is 0.37, 357 to... Back and said, so your calculation of it being 8.8 millimeters versus in the 9 millimeter range, that would be incorrect. And he said, yeah.
I believe that's not what he said. I don't think.
And let's resolve it now if we can.
I don't know if I have this summarized. It was so recent that I don't. I'll have to look at the actual
Wouldn't
testimony.
that actually go to the weight in any event? We're talking about 1/10 of a millimeter.
It may. I want to see what his testimony was. If he disavows it at some point or it becomes useless, it's possible. I need to look at his testimony.
Yeah, I misspoke. 1/100th of an inch is what I meant to say.
Okay, next.
So
Well, actually, it's your objection. You have the burden to show me, get the testimony, and show me that it is completely disavowed as opposed to whatever. So at this point, the objection is overruled with the possibility that the court will change its mind when you have a chance to go through it. The next one is D12, shot and powder burn through cloth.
Based on the previous rulings.
The objection to D12 is withdrawn. It is admitted in evidence. G12, I don't really need any argument. That is the compilation of Ms. Laughlin's chart. It is not, and basically it was used to refresh her recollection, and that's what she stated. You cannot use this. I'm not going to admit it. You can use it in argument if you want as a summary chart. But it's basically she used it to refresh her recollection because she didn't have an independent view, and that's not admissible as an exhibit. That's what it came down to. But you may use it in argument if you wish. It's no different than if you made a chart. Just keep the exhibit number off of it. Okay?
Okay, that's the last one. But
Okay. I guess we'll start with your instructions tomorrow.
we still have to, I guess we'll do this tomorrow. We have to bring you Lana Clarkson dates that, of course, we argued about this, I think, yesterday or the day before. The ones that correspond and some do not, but are clearly events that...
Oh, her day book you want to show.
Right, and what we suggest we did is go through it so you don't have something like this and just pull the particular ones out. Okay.
Your Honor,
Yes, Mr. Ridden.
in order to facilitate things for tomorrow, we submitted a memorandum opposing lesser included offenses. I wonder, without getting into any discussion or argument now, the prosecution had addition lesser included, so we'll know whether that's going to be the subject of some discussion tomorrow or not.
It may be, we'll let the court know the first thing in the morning.
We're looking at that.
Okay.
We're looking
All right.
at exactly that issue.
Actually, we had one more, a couple of exhibits we wanted to talk about.
Okay, that's
We're moving
fine.
a little fast here. Let me,
Oh, we have time. We're fine.
thank you. It'll only take a moment. Let me give these copies to Mr. Rosen. I'll just have a moment. Do
Okay.
we have the Elmo fired up, or maybe we'll just give the court a copy? These relate back, Judge Sortino's letters to Dr. Laxmanan.
Yes.
There are two letters that we think, based on the court's ruling on that, fall into the same category. They're self-authenticated letters. I can hand them up to you. Maybe it'd be easier if you just looked at them.
Okay.
These have to do with letters to Mr. Shapiro, one both written by Doug Sortino, one under my signature and one under his, asking for those pieces of evidence that all were discussed at the Henry Lee hearings. Would you like an approach?
Yes, please.
Do you want me to give these or?
No, those are for you.
Oh, thank you.
You make it.
Sarcasm is still dripping.
Oh, Mr. Dixon is never sarcastic. It's not capable.
Never been known to have a dry sense of the...
Someone refresh my recollection. Did Mr. Shapiro actually testify in this trial?
I think that's also considered slightly sarcastic. I could be wrong. I could be
On
wrong.
the same day, Manin and Doug Sortino.
It is well.
That's right.
Yeah.
That's right.
All right, yes. As we go down a highway with no off-ramps, okay.
But based on the court's ruling, and I don't have those numbers right in front of me, but with respect to the two letters that then Deputy DA Doug Sortino sent to Dr. Laxmanan's office that neither of them ever testified to.
What's the purpose of the letters? Okay, fine, let's assume that they're self-authenticating, that Judge Sortino sent these. Now, what's the relevance of them?
Well, in light of Sarah Kaplan's testimony that she was there with Robert Shapiro at the time that Dr. Lee, according to Sarah Kaplan, picked up and pocketed the evidence, this is a request for that. And I think it's offered for that non-hearsay purpose to show that we asked for it and they...
Boy, you said that with a straight face. Now, there's a little upturn at the end of your
That's
lip.
only because you're encouraging me.
You've already brought in the snarling objection.
Anything else you want to offer?
Pardon?
Is there anything else you wanted to offer along this?
No, just those two letters. I mean, sitting there listening, and it seemed to me that those just matched the same ruling with the Dr. Luxman.
No, it's different. It's different. There's a lot that's being assumed in this letter, and the purpose that it's being offered for. Truthfully, I suppose, though we certainly rejected it, we litigated, and there that I guess Mr. Shea.
Well, I mean, it's late. We have nothing else to do in the next 2 minutes, so if I could just make okay. Robert Shapiro is the head of their defense team, and it goes to the same kind of showing their state of mind, his state of mind, just like Dr. Luxman. It's exactly what they want to use those Luxman letters for, is to show that they were put on notice of the information that was contained in the letters. They came from the district attorney's office. We wanted the fingernail, just like they're going to argue that Mr. Sortino offered this information to them and they turned it down. It's the same kind of, I don't know. I'm obviously that's why you're there and I'm here. Like it's the same thing to me.
That's why he's there, you're there.
That's right. I just conceded that, Mr. Bernard.
To introduce these letters is denied. Thank you, though.
I think that account has 4 denials, Your Honor. I think he...
Result will be the same. Do we have the people submitted a package of instructions yet?
Not yet, Chet. We're
Anxiously awaiting.
we're working on those feverishly.
I will tell you that what I'm thinking of doing, I have not done it before. However, I may have mentioned it, maybe not. It has been done, other judges do it on a regular basis, is that they give a copy of the instructions to each juror, and I think I'm going to do that in this case, so I'm going to put everything in booklet form, and then they'll have a booklet to follow, an individual booklet to follow along with, rather than just getting it at the end. It doesn't change anything, it's just that there'll be a little time where someone will have to reproduce it, since the court, probably the people will be doing that.
Is that going to be a booklet that's going to be provided just for the reading, or is it going to be...
Oh, no, they take those into the jury room.
Okay.
Your Honor, the people have submitted one instruction on what obviously is an important issue for tomorrow on the Baden Lee missing evidence disclosure issue.
I don't think you want to bring Dr. Baden into that one, it's just Dr. Lee, so I understand.
Well, actually, they've requested instruction on both.
Okay, I didn't realize that.
No. Counsel doesn't know the facts of the case. There are 2 different discovery violations. There are 2 point instructions.
Okay.
Baden has one, Lee has the other.
Mr. Jackson, you've submitted 2 instructions. One is on Baden.
Gentlemen, not important. But what did you want, Mr. Reardon, from that?
The only point, Your Honor, is that there are 2 proposed instructions. We have submitted a brief today in opposite to those instructions, so that should leave the court to determine people's proposal in our opposition.
Where's your brief? Wendy says she put it on the bench. Let me see.
We found it this morning.
Did you want me to mark these 2 letters as exhibits?
No.
All right. Here.
Not with the reception.
And I think this is your copy. You gave me this exhibit to take a look at. Okay, I have it. It's part of your packet. I'll take a look at it.
Yes.
And Your Honor, we also did submit one proposed pinpoint instruction on the defendant's behalf, and that should be there as well.
Okay, that's the only pinpoint one you'll be submitting? No.
I don't know until I see perhaps what the people are going to propose.
Okay.
I think there almost surely will be proposals concerning one other major issue, which is the court's instruction on the 1101B material.
I should indicate, although I think I said something to the jurors, and it's important that I think that we have an instruction that would be based on the case People versus Cox. It's not the only case about how they can use the other guns. It's very, the guns were used for specific purposes, the limitation on that, how the jurors can consider that. So something to consider.
Yes, and also I think the court had visited this issue a few times during the trial about the 1101B pinpoint.
Right. Well, 1101B has to be, there's a limitation on how you can use it. I mean, you can pinpoint it if you want. The bottom line is there's, I'm aware of my responsibilities. If the instruction is pinpointed, which is basically to take the general law and relate it to the specific facts of case. Such instruction cannot be argumentative or misleading or anything else, which is why they're often refused. But I fully understand. I don't have a sua sponte duty, but if one is proposed or more is proposed, I have a duty to look at it, and I understand my obligation, and we'll go from there. And I think for today we're done. And what time do you want to meet tomorrow?
10 again, okay?
How about 9:30? 9:30? Day, I'm sure if this will put this should be the fatal blow to the court TV. This will do them in. Okay.
Cookies didn't do them in?
Yeah, right. We're in recess.
I will be on vacation and it's going to be an experience here and here. And any other exhibits that you guys, we're going to redact or look up things on and come back with the court. Can you do that when I get back? You're not talking about those while
When will you be back?
next week.
Okay, done deal.
Thank you.
Okay, done deal.
Okay, charging conference, I hope. And I hope it's a short one. Two hours. What time is it? I don't think we're going to get to closing arguments today, y'all.
Back on the record. Counsel is present. Okay, what would you like to take up first?
I think we're going to do jury instructions.
Okay, do we have any further matters to do concerning exhibits?
I think where we left is Wendy asked us to wait till Monday or when
Well, we can tell her I need to have we're not going to be here Monday. We're not going to be here Tuesday.
Okay.
We won't be here till we're ready to argue to the jury. So I'd like to get these issues resolved. And
I can resolve the ones that I can from my side.
okay.
Judge, with regard to I'll start with my evidence and then move to the defense's evidence that you requested. With regard to People's 172, that was the DMV photo of Tawny Tyndall.
Yes.
That has been redacted and supplied to the clerk and to the defense.
Okay.
With regard to Lana's resume, the court asked me to look through the transcript, call through and see if Nick Terzian actually established the foundation for that. I believe he was asked questions about it, but it wasn't published, it wasn't shown, there were objections, the court sustained the objections, I moved on. So we're not going to be asking for that.
What
it's
number?
173.
173?
That's correct.
All right, 173 is not admitted in evidence.
With regard to the rental agreement, Mr. Plord simply asked, and that's People's 185.
Okay.
We make a courtesy copy for the defense. That's being done.
Okay.
And that takes care of the people's evidence.
Okay.
With regard to the exhibits. With regard to the defense exhibits, I would point the court to the following. R to the 5th.
Okay.
That was that close-up photo of the looking down the barrel of the gun.
Yes.
If the court looks at page 5114, that specific exhibit was used by Mr. Plord with Steve Renteria. We would ask for its admission.
Okay. R5 is admitted.
Thank you. With regard to Y to the 5th,
Okay.
that is a photo of the chair from the back. Mr. Plord said, I don't think we used it. If the court were to refer to page 5136, that photo was used with Steve Renteria. The foundation was laid, and he did use it.
Y.
Thank you. With regard to
Page number on R5, you said, I don't get
5136,
that was Y5, R5.
R5 is 5114,
Thank you.
both under Steve Renteria's testimony. With regard to C to this page that showed, the box was checked that showed Mr. Spector had urinated.
Yes.
Okay. This is what I would point the court to. It's page 7702. Question. This is on cross-examination. If you'll bear with me, it's very short.
Okay.
Question. That would indicate if, in fact, Mr. Spector urinated before he gave the sample, that would be consistent with a void of the bladder, correct? Answer. If that is what that means, or I'm not sure if that refers to an actual void itself, or if that refers to a prior void, I'm not sure. Question. Okay. And that's under something, that is under not a portion that's called sample, it's under a portion called, quote, recent hygiene information, end quote, correct? Answer. Yes. Mr. Middleburg indicated if that's what that means, that it was under recent hygiene information, if that's what that means, then yes, it would indicate he voided his bladder. And then he goes on to say, I'm not sure if that's what that means. That goes to the weight, not the admissibility. We would seek its admission.
I agree. If anybody argues that if it's an issue, clearly the test C6 is admitted.
Thank you. And this one. The last one I believe that we need to cover is Y to the 11th. Okay. That was the chart that Dr. Spitz on Sir Rebuttal or Sir Rebuttal, whatever it was, indicated he did the 357 analysis.
Yes.
We objected to it on page 10,564. Dr. Spitz agrees. We didn't have the transcript. Okay. We read the transcript this morning, and basically Dr. Spitz agreed. I asked the question, so if your math is incorrect, and in fact it's a 357 or a .357, not a .347, that would render the chart inaccurate, and his agreement was, his statement was okay, which is not the best thing in the world, but certainly he was agreeing that if his math is wrong, the chart's wrong. And my position is, if his math was wrong, he agreed that he was talking about the interior diameter or bore diameter, not the width of the actual projectile. That's a huge difference. And although Mr. Plord said yesterday we're splitting hairs, we are splitting nerve fibers. It's a huge difference between the size of the bullet passing through a very small spinal cord, and they're trying to make the bullet very small and the spinal cord very big, when in fact that's not accurate. I think that chart is misleading, and he admitted that it's misleading. We would ask for it to be noted. And that's it for us.
Ms. Berenger helped me with this. This was not my witness, but as I recall, the only part that he was responding okay to was just that one area that Mr. Jackson cited. The rest of the chart, there was no problem with. So as an alternative, what we could do is we could just redact that one part and get the argument. But the rest of the chart, I don't think there were any quarrels with or any problems with it. It's just that one area.
The chart's a comparison. It's literally comparing and inaccurate.
The way I believe it should be dealt with is I think the exhibit should come in, and you pointed out, I mean, you have the testimony, and that's the bottom line. He used the chart, he relied on the chart. Yes, he admitted there were problems with the chart, and I think the way you deal with it is basically, you know,
Then we'll submit.
deal with the testimony. So Y11 will be admitted.
Okay.
Do we have any other exhibits that we have to deal with? Outstanding issues?
Not from the people. I think that covers the ones that you asked us to inquire to look at. We still have yet to get, there were a number of redactions, et cetera, that the court ordered from the, yet to see those. So,
Yeah, when you see them, when you come back, you'll let me know if it's not.
Find some citation stuff. We're still working on it. In fact, as we are here, people are working on it.
Okay, that's fine. Do we have a, do you have a package of instructions? Have you given a copy to the defense?
I did.
Okay.
One packet. The packet for the judge.
Let me go get my glasses. I don't need the eye strain today, so hold on a second.
I had 4. We also have, while we're waiting on everybody to come back, here's my notes. I would offer the court some light reading on the issue that Mr. Bruno brought up yesterday, the use of video imagery during final arguments or final summations.
Okay.
This is the Condella case. It's sort of the lead case that every other case seems to cite on that issue, as we're sort of breaking into new technological ground. That court made certain determinations concerning the use of video imagery that was used during the trial, or that was taken, rather, of testimony during the trial. And it sets the standard and sets the rules. And
okay.
We can argue it at a different time, but I just wanted you to be armed with the...
Understanding, of course, that a decision of the New Jersey Supreme Court.
It's persuasive, I understand.
Persuasive only.
But because this is such a new area, Judge, I don't know that you wouldn't be the first trial court to address it in California, quite frankly.
Although we, with respect to Sarah Kaplan, at one point when we thought that she would not testify, we may have been in chambers, but we were on, Mr. Rosen may recall this, we were all sitting around, and I think the court assumed that we would read that testimony in, and we said, no, we would play the video of her testimony, and the court seemed to have no problem with that.
Okay.
Well, that would be a very different animal.
I understand. I'm going to give it some thought. All right. Shall we begin?
Yes, Your Honor.
Yes.
It might be helpful if I stated where I think we are, and,
Okay.
and we've had discussions with the prosecution. I think we have agreement on well over 90% of the charge, and I think that there are 4 issues to be addressed given my discussion with Mr. Jackson and Mr. Ocampo.
Okay.
One of them is Crim 359, dealing with corpus delicti. The prosecution has requested it, and we'll explain our objection to it.
Okay.
The second, the next 2 are the ones that the court was well aware were coming. Whether there's going to be a special instruction based on Cal Crim 306 dealing with the loss or delay. The prosecution has proposed 2 specials. We will initially take the position, strong position, that the court should not give any instruction under 306, but alternatively, well, if the court in just a second.
Okay.
The prosecution has a proposal on 375, which is the CalCrim instruction on uncharged offense of conduct or statement evidence. We have our own drafted instruction on 375, which I'm about to hand to the court. We did ask for a very brief pinpoint instruction that I believe. So that's 4 issues. The 5th one is not really an objection as much as some elucidation. The prosecution has asked for 371, Calcrim 371, dealing with potential fabrication of evidence by the defendant. Based on my discussions and understanding of the record, they are probably entitled to that, but we will merely ask for a specification of what evidence the prosecution is seeking to have that on, so that the limit of the instruction would be clear. And with that, Court's permission, I'll approach with what's called Defense Proposed Instruction 2, which is on the 1101B evidence, and Defense Proposal Rate Calcrim 306, which we don't want the Court to give, but it's our fallback position if the Court decides to instruct on them.
Thank you.
But as we probably agreed on 25 or 26 other Calcrim instructions, and if the government wants to, if we want to just run through the list, we could.
I'll tell you how I do it, and so it'll
Sure.
probably make life easier. What I do is I take the title of the Calcrim instruction and ask what's your
Quit buffering.
My wife would occasionally like to see me. Well, maybe not. I'm really going to check on that. I'm not totally sure on that.
I can help you. Give me your vacation days. I'll take them.
I want a phone number because even though I'm not going out of town, I'll just be home. I tend to read through the jury instructions and through Calcrim 4 or 5 times, and just to satisfy myself. And if I find something that I think I have a sua sponte duty to include, rather than hit you with it on Wednesday morning, I'll call you so that you can work it into your arguments, basically. Normally, it wouldn't be anything that crucial, but just so that you're aware, or I'll get a number from the DA and call them, and they can call Mr. Rosen, or however you want to do it, you know.
Thank you, madam.
That's fine. However, we can agree on that, how we want to do it, and that's, you know, so that nobody's caught by surprise. Okay, let me just go through here and make... All right, let's start with 200 duties of judge and jury.
Well, this may be it was reported, I saw this morning, that Mr. Reardon has been
Saw the same thing.
subbed in as chief counsel, amazingly enough.
I think that was a little bit of perhaps mistaken hyperbole. As my understanding, Mr. Reardon is here to consult and to serve Mr. Rosen as chief counsel, such as there is one that we rely on. I mean, Mr. Brunon is still part of the team. Is Kenny Bodden is part of the team? Is Mr. Clord still part of the team? And Mr. Rosen, and those are the attorneys. Mr. Reardon, as I understand it, is here to work on jury instructions and to assist the defense. Is that correct?
That's absolutely correct, Your Honor. And
you don't control press statements, I understand.
I do not, Your Honor. It may have been a mistaken reference to a belief that I'm a Native American and chief was a proper noun, but no, I am not chief counsel and will not serve as such.
All right, no problem.
My concern was, and I think the court has cleared it up, if Mr. Reardon is going to be making the arguments on behalf of Mr. Spector, I don't know if the court needs to take the step of having him either associated in as counsel, or if Mr. Rosen is simply going to make the representations on the record. Mr. Reardon is not a counsel of record for Mr. Spector, and the record is going to look funny with someone new speaking it. I just want to make sure everything's...
Are you going to be addressing the court, Mr. Reardon?
Well, I am going to address the court.
For the purpose that we've indicated here to work on jury instructions, Mr. Reardon is, now part of the defense team, and he may address the court. Okay?
Thank you.
Thank you.
All right. CalCrim 200, duties of judge and jury.
We'll join in the request for that, Your Honor.
Okay. Let me indicate, I will go through, I don't know if the people have already, to the degree, a modification to take care of gender issues or anything like that. Have they been?
What I did, Judge, and this is my normal standard operating procedure, I use a pencil and I go through very lightly. I make the modifications that we suggest. There may even be some writing, but the modifications are very clear underneath, so you can see anything that we've proposed to be redacted, and the defense can see that as well.
At some point, when we reduce to book form, I would hope to have Wednesday morning. Even if we don't, if there's something happens, we have basically 2 days to do it while the arguments are going on. You know, we have people in your office that can assist us, so that's not going to be a problem.
Okay.
All right. And I will go through them, and if I find something in my review while I'm home, certainly I'll just go ahead and take care of that. Those are not major modifications. All right. It's requested by both sides. It will be given as requested. CalCrim 201, duty not to investigate.
We did a modification on that, Charlie.
Okay, and the modification, oh, I see. You put the actual.
I made reference to the jury visit too.
Okay,
Otherwise, it didn't read right.
Let me read this. Hold on a second. That's fine. I don't have any inclination to go ahead and view the scene. That would specifically tell them, don't do it.
I will join in the request.
Okay, thank you.
Excuse me, I didn't hear Mr. Reardon.
He's joining.
All right, thank you.
Thank you. Okay. CalCrim 202, note-taking.
Is there any need for a special reference to juror number 10?
He's our most avid note taker, which everyone has noted. Our engineer, he takes copious notes.
He's on his 13th notebook, I understand.
Hey, that's up to them. That's what they're told before the trial. It's up to them. Whatever works for them. Is the defense joining?
We have no objection to, Your Honor. Something like this may need to be modified depending on the outcome of a ruling on whether videos of the trial are going to be used in the case. But why don't we simply don't object to that.
That's fine. Thank you. .220, reasonable doubt.
Join in the request, Your Honor.
All right, thank you.
Hey guys, I am sorry to do this to y'all. We're gonna have to quit there today. I am in a lot of pain and I'm gonna have to go lay down. So, we're not gonna be able to get through jury instructions today. I apologize. I wanted to get through them, um, just as much because I wanted to get through them and get started with closing arguments and get done with this trial because we have been on this for a long time. But I gotta go lay down. I'm in a lot of pain. So I'm so sorry. But we will pick this back up in the morning. I apologize because I wanted to get through this today and get closer to closing arguments and be done. Um, oh, I don't know why the sound is low. Sorry. So we'll pick this up in the morning at 8. I'm gonna go lay down and hopefully I will feel better tomorrow. So I will see you guys in the morning. Bye.